Good morning, good morning, good morning. It's day pause in week 8 of the Commonwealth versus Karen Read because today is Voir dire. Why is today a Voir dire day? Well, there are some defense experts that the court wants to hear from before she makes a ruling on whether or not they will be allowed to testify. The Commonwealth brought a motion to exclude these defense experts, and the defense is opposing. So the voir dire process allows, outside the presence of the jury, for those experts to be questioned and for the court to answer those questions and determine really what the solution is if there were any violations. I think the court is very hesitant to keep out defense witnesses at this point in trial and wants to give the opportunity to the state to be made aware of what they would say were the discovery turned over properly. Remember, there's reciprocal discovery in Massachusetts. The defense needs to turn over who their experts are, what they're going to say, their reports, how their conclusions are based, what their credentials are. And if that's not been turned over, to give the state a fair heads up. Well, this allows for a fair heads up. So that is the purpose of today. Chat, let me know where you're coming in from and what you are drinking. My voice is a bit cranky. I was trying to steam it just a little bit this morning to hope that I don't lose it, but I can definitely feel it. So thank you guys. It's just my voice is giving me all of the business today and yesterday. So we're going to do our best. And if I am quieter, that is why. So let me know what you're coming in from, what you're drinking, and let us zoom right into the intro. I've got greens. Let me know what you're working with.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
And since I doubt it's going to happen today, we're going to do our own. Just, we need to
bring the jury.
And hear ye, all law nerds gather, draw near and give your attendance, and ye shall, well, hopefully have a spicy court hearing, and we will see what happens. And chat, I'm sure as friends wander in, they will forget we were outside the presence of the jury. So it's okay to just remind them or not. It's up to you. Be as sassy as you like with that. It's like, no, jury's here. No, I'm teasing. Let's go to court and see what happens today, shall we? Remember, tomorrow's a day off. My voice absolutely needs it.
22-117, the Commonwealth versus Karen Read.
That's not even loud enough. And it is gained.
All right. Good morning, counsel.
That's better. That's not better. Immediately with the spinning wheel of death? All right.
They are your honor.
Good morning, Mr.
I'd like
Lally.
to hear from Dr. Russell first.
I don't know how that feed jumped so fast.
Counsel.
There we go. Nope. Oh, is it going to be like that today?
I'd like to hear from Dr. Russell first. Are you both prepared to?
It's going to be like that today.
I could not hear you.
I would like to hear from Dr. Russell first. Is that her name?
Dr. Russell, yes.
The judge already sounds annoyed. But also remember, from those I have talked to that are in the courtroom, the sound is very difficult. The fans and AC have made it very difficult. So even that close, they can't hear each other well. So even if the judge sounds frustrated, it could well just be that is how the judge sounds trying to project, and they can't hear each other.
Based on scheduling, Dr. Russell, Dr. Wolfe, Dr. Rintscher.
Okay, then that's...
I cannot with the spinning wheels. Anika said no spoilers. If there's already spoilers, please no spoilers. We're just going to go through this today. Again, we're outside the presence of the jury, going through the defense experts. But the feed struggling is...
They are your honor.
I'd like to...
going to frustrate me. All right, let's try this one more time.
22-117, the Commonwealth versus Karen Read.
It just doesn't want to be on stream.
All right. Good morning,
Fantastic.
counsel. Ms. Reed.
There we go.
Are all of
These
the
are
witnesses
defense
here, Mr.
experts.
Jackson?
They are your honor.
I'd like to hear from Dr. Russell first. Are you both prepared to?
Your Honor, I'm so sorry, I could not hear you.
I would like to hear from Dr. Russell first. Is that her name?
Russell. Dr. Russell, yes. The order would be, I would propose based on scheduling Dr. Russell, Dr. Wolfe, Dr. Rintscher.
Okay, then that's good because that's the order I prefer. So, all
Well,
right.
they're all on the same page.
Do you have a
for the
CV
moment, at
for her?
least.
Good morning. Morning, Tori.
A resume.
Do you have a CV I could look at for her, please?
Let me see if.
Debbie asked, why didn't the Commonwealth have to do this with their experts? Because their disclosures were met. And the one time their disclosure was not met, the expert was barred from the testimony.
And she has not written a report?
Barring the defense from testimony is a much bigger thing and would be a
All right,
much
let's
bigger
bring her in,
problem.
please.
And could be a much bigger problem.
Your Honor, before
That was
we
my remarkable
get
out of
started,
battery.
Can I get an understanding? We started to say
Hold
that,
on, grab my
sidebar
notes.
the other day, and you said you wanted to put that off to get to the witnesses. But I need a little bit of an understanding of what the court's expectations are. My understanding of voir dire, which this seems to be unusual in terms of the timing of it,
The understanding of the voir dire is this is for the Commonwealth's motion to exclude this testimony. All right, that's what we're here for, the Rule
Is that the same?
14 violation.
is that the same with Dr. Wolfe and Dr. Rintscher?
Well, I thought that would
Yes.
help both of you. The Commonwealth
yes,
has
it's the
nothing on
same.
that, and you say you haven't been able to even talk to them at all about this case.
That's correct.
So I want to find out if they have any credible, competent evidence to put forward.
Motion
so we'll have a voir dire
To
on them this
exclude.
But
So
for
that-
Dr. Russell, what we're doing here today is there's an alleged well, there appears to me to be a violation of the reciprocal discovery obligations of
Okay, let's
defense
find out
counsel
why.
regarding Dr. Russell. So let's hear from her today to see what the appropriate remedy is for this violation.
So my intention is to ask her.
This is based on the
So I
state's
have-
motion to
the court
exclude.
understands my sort of guardrails. My
Does it get
intention is to
excluded or
ask
not?
her what her qualifications are, which is that's the basis for voir dire. And that's where I'm going to stop. I'm not intending to ask her what her opinions are, conclusions. I'm going to ask her if she's
Yeah, that's
come
not
to
gonna
opinions
fly.
and conclusions, but I don't want to have to examine her concerning her
No.
full opinions or full conclusions.
That's exactly what's going to happen.
What she's based those conclusions on.
The whole purpose of the
Therefore,
hearing.
We've provided the defense the prosecution, everything that we need to provide to them in terms of disclosure.
Did you hear Alan's brain just default back into prosecutor mode? We've provided the defense. I'm sorry. The prosecution, everything.
They've got the equivalent of a report. They've got a summary of what she's going to testify to.
When was that provided? My order was 1 week from the start of trial, right?
But we didn't, Your Honor, in fairness, they didn't even finish their discovery 1 week before the start of trial. So it's a little unfair for us to be put on the same.
1 week from the filing of the certificate of compliance.
Well, I don't know when there's, I can't remember. My co-counsel indicates it was the day before trial.
Okay.
So during the course of, look, the trial is a dynamic thing. During the course of the trial,
yes.
I did not know who Dr. Marie Russell was at the time that they filed.
That you started trial?
We then attempted to and did
Really?
give them the reciprocal discovery that we were obligated to do after they filed their certificate of compliance.
When?
Within 3 days of that. We had been giving them
Within
information
3 days of
prior
the
to that,
certificate of
at least
compliance?
Within 3 days of that. We've continued, so the record's clear, we've continued to get additional discovery from the Commonwealth in notices of discovery throughout the trial. They have not finished. In fact, during the trial, they interviewed Jen McCabe, apparently, had a full interview with her. Lieutenant Tully took a report, dated the report, and then they held on to that report until after she testified. The interview, the report, and the completion of the report were all done before her testimony.
Do you need to call her again?
Your Honor, that's not my, and I think the court understands, that's not my point. My point is not, I need to call Jennifer McCabe back. I've done the damage that needs to be done on Jennifer McCabe.
Oh.
The point is,
I'm sorry, I missed that. You've what?
I've done the damage that needed to be done on Jennifer McCabe. I don't need to call her back. The point is,
And the judge said, okay, so if the prosecution didn't turn over this report to you, do you need to call this witness back? If you need to call this witness back, then that's the remedy. You call the witness back. He's like, I already did the damage I need to do to Jen McCabe. So if you know how the defense is feeling about Jen McCabe as a witness, there's that. I've already done the damage I need to do to Jen McCabe, but they're trying to figure out what the remedy is here for the discovery violations. So we will see.
That what's good for the goose is good for the gander. The Commonwealth doesn't get to stand in the position of piecemealing and feeding us information, reports, discovery.
Well, that's kind of what you're doing too, though.
And by the way, when we then
Jackson.
got seminal information about an expert that we did not know about, never met, never heard of, within 3 days of that, we provide everything that we have about that witness to the Commonwealth. They can't then turn around and say, oh, well, it's all the defense's fault. So we want to have a voice.
Well, if it's a discovery violation because you didn't turn it over when the judge said you had to turn it over, the remedy is normally keeping it out. This is a criminal trial. The judge doesn't want to keep it out. But if this is your doctor going to the scratches on the victim's arm, I find it interesting that they didn't have an expert to testify to that until the middle of trial. Like, really? So you were making those assertions in court based on nothing? Based on what? Who were you going to call to prove it? Interesting.
Here, which means the euphemism for that voir dire is we want to have two bites at the apple.
Okay.
We want to be able to completely.
She doesn't like the hyperbole at
and
all.
Go back to our expert, and if she testifies,
well, that's the point.
Cross-examine her again after consulting with our expert.
That's literally the point of expert disclosure. Expert disclosure means you turn over what the expert's going to say and what they base that on. The state takes that back to the expert that they have, and then it comes in trial. So that's where we're at. That's literally how that works. That's not two bites at the apple. That's just how that all works. I understand he's trying to say it's two bites at the apple and that some who like him are going to be like, yeah, that's fine. It's two bites at the apple. But that's what expert disclosure is. And because the Commonwealth is saying that that was not done, yes, they get to examine your expert now. Then they get to go back either to their expert or not if they don't have one, and they get to prepare for it.
Two bites at the apple, and that's not fair.
And I think the judge is going to give the prosecution broad latitude here because the judge isn't going to keep it out. So I think that's why we're getting broad latitude here. And I think we will see broad latitude here. He's already mad.
Dr. Marie Russell is qualified to testify about the arm injuries. That, I believe, is the parameters, the proper parameters of the voir dire, and that's what I'm prepared to do today.
Yeah, that's not going to happen.
But I wasn't planning on getting into the substance of her testimony because that's been provided.
Has it?
I think Mr. Lally should be able to get into the substance of her testimony because he knows what the substance is because, like I said, that's been provided.
All right, so
Mammy of three, defense doesn't have to prove anything. But they said in their opening that they were going to, so it seems that they have an expert that is going to help. Dissimilate said, how are they supposed to do that when the judge ordered them not to talk to the witnesses? That's to different witnesses, not to this doctor. So that's to the later witnesses that we're supposed to see. That's a whole different beast.
I disagree. I'm going to hear from the Commonwealth on this. Is it Ms. McLaughlin or Mr. Lally?
Yeah, the court's not happy with this.
Your Honor, just briefly in regard to what counsel was referencing with Ms. McCabe, it was not a full interview by Lieutenant Tully.
Why are we still talking about Jen McCabe?
And I don't have it on me at this moment, but I can give the court a copy of that report. But essentially it was
eyes can't
Ms.
roll
McCabe
enough.
met with Lieutenant Tully, looked at some video, and was asked a single question. That report wasn't available. I didn't have it until after Ms. McCabe testified, but it was given to counsel prior to Lieutenant Tully testifying, and there were no questions asked of Lieutenant Tully in regard to that. My issue, and I wasn't asking for a voir dire as it proposed to, as it relates to Dr. Russell, is that we first heard of Dr. Russell on May 21st, which was, I think, 6 weeks into trial.
Yeah, the Commonwealth doesn't want this voir dire either. The Commonwealth wants it kept out. The Commonwealth knows that the court is giving them a voir dire as a remedy because the court is very unlikely to keep it out. So the Commonwealth feels like they are being sandbagged and that this is being sprung upon them, and they are very upset that this is going to be allowed. So they don't want the voir dire either. They're like, this isn't a remedy for us, keep it out. The reason they're getting the voir dire is, in my opinion, and this is me forecasting based on what I'm seeing the judge do, the reason they don't want the voir dire is they want the judge to just keep it out. The judge isn't going to do that. The judge is going to give them an opportunity and be like, you've now had the opportunity. You now have the information. This is what happened in Murdaugh. Look, you've had the opportunity in the voir dire, so it's coming in.
Trial.
Right, so that's what I asked, and you told me it was 3 days after the beginning of trial, Mr. Jackson.
Your Honor, I said I
He did not say it was 3 days. Oh, they're already fighting. Jackson did not say it was 3 days from the beginning of trial. Jackson said it was 3 days from when the Commonwealth finished. Lally is now saying this was not disclosed till 6 weeks into trial. We're on week 8.
As it relates to Dr. Russell, is that we first heard of Dr. Russell on May 21st, which was, I think, 6 weeks into trial.
Right, so that's what I
too
asked,
far
and you
in.
told me it was 3 days after the beginning of trial, Mr. Jackson.
Your Honor, I said I said this at sidebar the other day, and I just said it again today. I let the Commonwealth and the court know about Dr. Mallory Russell 3 days after I learned about her.
That's
which
not
was
exactly
the
what you said
17th
either.
of May. I had never, I think it was the 17th of May. I had never heard of her. I didn't know who she was. We made contact. I determined that she
I can't believe they went into this with no expert to talk about animal scratches, animal bites, animal whatever. I can't believe it.
would be useful for the jury in terms of specifically the injuries to John O'Keefe's arm. I then had one conversation with her, then immediately, within 3 days of that, turned that information over to the prosecution. So I didn't say that I gave this over 3 days into trial. That's not what I said.
All right, but you were ordered to do it, Ms. Gianetti. What was the date? What you had 1
3
week
days after
from when?
certification. I don't like how the judge does that. When she doesn't want to hear from Alan, it seems that she just asks Gianetti. Gianetti's not the one arguing this. Jackson was.
The day before trial. So it would have been, I believe, April 15th. So what we knew as of that date, you were required to turn over.
I need to take a quick listen.
What? All right.
And the court has walked off the bench. Good. The court has already walked off the bench. These are not the federal witnesses. This is a separate witness who is a doctor. I believe this is all going to the victim's arm injury. Oh, the judge walked off to grab a book. Probably the rules of evidence. Yep. Well, at least it was quick. I'm going to zoom while the court is looking at the rules of evidence, or the Massachusetts rules of evidence, because that seems to be what she has up on the bench with her.
Motion, the Commonwealth's ruling.
All right.
Include the testimony. So that the Commonwealth, I've got it, yeah.
Okay.
All right, so the Commonwealth has moved that I exclude the testimony of.
I'm going to back that up. Every judge I know writes in their book. Do I have that one? No, that one is going to be the Massachusetts rules of evidence. I have the federal rules because every state is based off of it.
Move that I exclude the testimony of Dr. Russell based on a violation of the reciprocal discovery obligations of the defense. So I do find that there is a violation of the reciprocal discovery obligations of Rule 14.
Okay.
And I'm quoting from the notes, the importance
She
of
finds a
this,
violation.
the reporter's notes to the old rule. And as you all know, we're in the process of updating that rule, but the very integrity of the judicial system and public confidence in the
That's what
system
she was highlighting.
depend on full disclosure of all the facts within the framework of the rules of evidence. To ensure that justice is done, it is imperative to the function of courts that compulsory process be available for the production of evidence needed either by the prosecution or the defense. So, what we're here to do today is decide a remedy for this violation. And that's why we're having a voir dire. I am not prohibiting the Commonwealth from anything on their examination of witness Mr. Jackson.
Broad
The
latitude.
alternative is she
So-
doesn't testify.
Right.
So the Commonwealth has not received the appropriate discovery from this witness.
And this is the
So we're going to
fix.
have a voir dire, and they can ask her anything that they think
Yeah,
they need
this
to
is the
ask her.
solution.
So those are the parameters of
I
this
understand.
morning.
As long as I know the guardrails, that's fine. I just to close the loop on the record.
When the crash reconstruction guy had a new opinion and didn't turn it over, the court kept it out. So the court kept the Commonwealth's additional expert opinion out. The court's not going to do that to the defense. It creates a much larger problem when that happens to the defense. So the judge's solution is, hey, the Commonwealth gets to ask the witness questions and prepare. It's the information they should have had, and now they get it. But the court's doing this because the court's going to let it in. So the court wouldn't be wasting their time outside the presence of the jury if she was going to exclude it. So she's going to exclude it from the prosecution. She's going to let it in from the defense, and she's going to let them ask. I think that's fair. And it gives the Commonwealth the ability to have the information that they want. So
My understanding, and this little can probably speak to this
Debbie,
more
they
intelligently
did
than
do
I
a
can,
voir dire
but
with that
during
witness.
the middle of trial,
They're not going
there
to
was a witness
deny
that we
this.
had never heard of.
I'd be
did not
shocked.
know and didn't have a report for.
Who is that?
Dr. Fowler, Faller.
Okay.
If the court remembers, he's buried in the middle of about 75 witnesses. So he testified to alcohol levels, et cetera, and protocols at which institution? At Good Samaritan. And we didn't have that information either. We didn't throw a fit. They said we were going to provide this information in a timely fashion. As soon as we know that we're going to call him, he's got to be on our witness list. We didn't know one way or the other what he was going to say. We didn't have a report, and we went on about our business. That's what.
And
we
that
did
should have
well.
been turned
And by the way,
over.
I would note.
And you
that
could have kept it
the
out.
Notes and the report under Rule 14 require disclosure of information you have. I just don't want the court to think that we were sitting on information that we didn't.
And that's fair.
No, I'm not saying that. It's just, this isn't as if it was something that the Commonwealth brought up and you needed to scramble. This is entirely of the defense position. So,
I understand.
all right, so that's the big difference. So why don't you go ahead and call her?
Okay. Yeah, I'd be excused to call it.
Yes.
And again, I think ultimately the court is going to let this in at the end of the day. Melissa said, can this be appealed if she keeps it out and Karen Reed is convicted? Then yes. If not, it'd be a really odd thing to take a writ on, but it's always possible. Gilgle said, question, does the jury get to hear the voir dire testimonies? Not today. If these witnesses are allowed, which again, I think that they will, but if the witnesses are allowed, the jury gets to hear them in the defense's case. These are defense witnesses. They are voir diring out of order, like they did in the Murdoch case, where things with regard to the financial crimes were voir dired a bit out of order, and then the jury heard them later. So we're going to hear from this witness now. If this testimony is allowed, again, I think that's what's going to happen, but we'll see. Then this witness will testify again before the jury, but they won't just get like a recording of this. So I'm going to try to answer as many questions as I can. Can the defense decide after voir dire not to call the witness if it goes poorly? They can. They absolutely can. How is it okay to exclude defense evidence that's valid? It's a proper sanction for discovery violations.
Your voice up, speak right.
But as to the defense, it rarely is kept out. This is normally the remedy for that. So
Right into that microphone, doctor, okay?
Yes.
Thank you. All right, go ahead, Mr. Jackson.
Thank you, Your Honor. Good morning. Could you please state your name and spell your last name for the record?
Yes. Marie Russell, R-U-S-S-E-L-L.
these are defense witnesses. So it should benefit the
And
defense.
I'm going to echo what the court just indicated.
though there are Commonwealth witnesses that I don't think have benefited the Commonwealth, but these are defense witnesses. The Commonwealth wants to keep these witnesses out. The defense wants to bring these witnesses in. The court gets to decide.
The air conditioners are on, so please keep your voices elevated.
Apparently,
as
it's quite
possible.
hot.
Maneuver the
Mass
microphone however you
residents.
need to, okay?
Apparently, it's quite hot.
Dr. Russell, what do you do for a living?
I am a retired emergency physician and forensic pathologist.
And tell me what education you have, going all the way back to the beginning, that qualifies you as an emergency physician and former pathologist before you retired.
Forensic pathologist,
Okay,
not just
well-
a pathologist, a forensic pathologist.
I've had about at least 16 years of formal education beyond high school. Initially, I started at MIT, where I
Right, so
did
you're
my
brilliant.
pre-med courses. I had always wanted to be a physician. And so I went to MIT for a year, took pre-med courses. And then I had an unusual life event in that my mother came down with cancer and she subsequently passed away. During the time away, so I took some time off from school. During that period of time, I decided to explore another interest of mine, which was law enforcement. And so I took some courses in law enforcement, and I became a full-time police officer here in Massachusetts.
What
Really?
years were you at MIT?
That was 1972 to 1974.
Did you go to the police academy?
I did. When once I became a police officer here in Massachusetts, I attended the Boston Police Academy where I graduated.
What year was that?
Okay.
That was in 1977.
During the course of your training as a police officer, did you have any specialized training in hit and run and accidents and investigations?
Yes, I did.
And which agency did you work for?
Wait,
as a
when
sworn
did you go
police
back
officer?
and become
I worked
a
for
physician?
the city of Malden full-time for 7 years.
That would be from 1977 to 1984, approximately.
Correct.
During that time, did you continue your education in any way?
I did. So I took as many courses as I could from the Massachusetts Criminal Justice Training Council, which included a several-day course in hit-and-run accident investigation. I took courses in forensic photography and numerous other things. And then, and I also at the same time continued to
We
go
love
to
a
college.
lifelong student. I
And I
know
did
exactly
that
what that is. Wait, ma'am,
part-time,
how did you have time?
where I
Ma'am, you're making me feel lazy. How did you have time to work as a full-time officer, continue your education within your field, and continue college? Ma'am.
eventually got a bachelor's degree of science in psychology with highest honors.
What institution was that from?
That was from Northeastern University.
And that was a Bachelor of Arts in Psychology?
I think it was a Bachelor of Science.
Got it.
Jackson,
So-
do not offend her by saying Bachelor of Arts. She's like, I'm sorry. It was a Bachelor of Science. The requirements are different and more. More science.
Subsequent to your Bachelor of Science degree from Northeastern, did you also advance your education further, formally?
Subsequent to. So yes, so I decided that I did want to pursue a medical career. And so I then attended medical school, University of Massachusetts Medical School,
Hey, go
full-time,
UMass.
for 4 years.
Did you ultimately get a degree, an MD degree from UMass?
Yes, a Doctor of Medicine degree in 1987.
So you were there from 1983 to 1987, is that right?
That is correct.
And did you do a residency?
I did. I did 2 residencies, actually.
Of course
Most
you
people
did.
do 1, but I did 2. I did. My first residency was a combined internship and residency for 4 years. And I did that in Los Angeles at Los Angeles County Medical Center, which is a very big
Yep.
trauma center.
Yep.
And what I would consider
Yes, it is a very
the
big
Bellevue
trauma,
of the West Coast.
trauma center.
Very busy.
You say
Yes.
that just because of the volume at USC Medical Center?
That is correct.
Is it one of the busiest medical
My sister-in-law
trauma
was
centers
also
in the
at
country?
USC
Yes.
Medical Center.
You were there from 1987 to 1991, is that right?
I did my ER internship and residency during those years. Yes, there.
During that time, were you seeing patients?
Oh, yes.
You were treating patients?
Lots of them.
Yeah,
You
she was in her
attending,
ER
attending
residency.
patients?
I was a trainee, so I was seeing as many patients as we could. There was always a waiting room full of patients, and so I saw many patients
always
during
a-
that time period.
There was always a
You
waiting
indicated
room
second
full of
residency.
patients.
Tell
Yes,
me about that.
Okay,
a
so
waiting room full of patients with gunshot wounds, I would imagine.
realized I had an interest in forensics, and I decided that I wanted to also train in forensic pathology. So I did
Of
a
course.
second residency in anatomic pathology, 2 years, followed by forensic pathology fellowship at the Los Angeles County Coroner's Office for 2 years.
And the years,
I've been
that's
there.
4 years, that would be
It
from
used to have a gift
1991 to
shop.
1995 approximately.
That is correct.
Tell me what your experience was as a fellow at the Los Angeles Coroner's Office, Los Angeles County Coroner's Office.
Yes, well, it also was a very busy coroner's office.
Yeah,
And-
I should have gone and got my LA County Coroner's hat. Emily, you didn't know what was coming. I didn't know what was coming. It's a hugely busy coroner's office. So if you're looking for high volume, ma'am, you found it.
And so every day there would be cases. I probably did at least 2 cases a day, most
that doesn't
days.
surprise me.
And plus conferences and educational opportunities. But the interesting thing about being a fellow is they try to give you a
All the weird
wide
shit.
assortment of cases. So, for instance, I not only saw numerous victims of gunshot violence and stabbings, but I saw numerous victims of motor vehicle accidents and natural death, overdoses, and then
Everything.
if there was an unusual case, it usually went to the fellow. Because the fellow
That's how
was
you
also
learn.
being supervised. So
Did any of those unusual cases, and we'll get more into this in just a second, but did any of those unusual cases include animal attacks?
yes,
Did you become a
Yeah, there are areas of LA that definitely have wild animals. Those are stories for another day. But wild dogs and like herds of wild dogs are a whole thing. The same with coyotes, but less human attacks. Anyway, if any of you feel like you cannot follow multiple interests because our society tries to tell you to not follow multiple interests, look at following all of the multiple interests. I love it.
a professor, an educator at any point?
yes. So during my 29 years at LA County
Oh, that's
Hospital,
a long stint.
during the last 25 of those, I was a assistant professor or an instructor, but mostly an assistant professor. And what that meant is that I was
Still practicing.
responsible
and
for
teaching.
overseeing the care that was provided by the interns and residents. So when a patient would come in into the hospital, the emergency room, they
Dr.
were
Bailey.
oftentimes usually seen by the intern or
Grey's
resident,
Anatomy,
and
just-
then I would go and subsequently see that patient also. So, and that was in addition to my own cases. So I'd see my cases and their cases.
And that was at LAUSC, correct?
That is correct. And
Can I ask
again,
a quick question?
yes.
LAUSC, for those of us who are not necessarily familiar with it, is
Shut up, Alan. You know you're well familiar with it. Ma'am, for everyone not from LA, for the court, ma'am, could you explain?
that associated with the University of Southern California Medical Center?
yes.
That's the school, in other words, the site.
Yes, so it stands for Los Angeles County / University of Southern California Medical Center.
And that's where you were an assistant professor for the majority of the rest of your career.
Correct.
Were you also an assistant or an adjunct professor at Cal State Los Angeles?
Yes,
Okay. For how long
They have
were
a
you
forensic,
an
a
adjunct
huge
professor
forensics
there?
department.
I believe that was 4 or 5 years,
Did you work in their forensics?
and I taught
At Cal State
criminalistics,
LA? Yeah.
forensic medicine there.
As an attending physician in the ER, in other words, a supervising physician in
Hey, Dr.
the
B.
ER, can you tell us what some of your duties and responsibilities
Alan found a woman that
included, especially as
forensic
it
at,
pertains to trauma, and then I'll get more
Cal State
specific
LA
in just a
and
second.
worked at
Okay.
County USC.
Well,
and did her residency.
So I would
USC
oversee the
to become a hair
care
doctor.
of all the patients that came in during a particular shift. And that would include medical patients and trauma patients. And as I mentioned, it was a very busy trauma center. So we had lots of trauma patients, including the types of violence I described earlier that I saw at the coroner's office, but lots of motor vehicle accident victims, because there was a highway there right nearby. There were a couple of highways, so a wide variety of accidents.
Did your supervision include assessing, diagnosing, and treating patients?
Correct.
In terms of the middle part of that, diagnosis.
Yes, say Los
it was
Angeles and
part of
motor
your
vehicle
job
accidents
to
together again.
determine the cause
They're basically
of
synonymous.
injuries, or to at least assess the cause of injuries.
Yes, and I took that on a little bit more because I was interested in the forensics aspect of the injuries.
The forensic aspect.
Yes.
Okay.
Triading number says she's the definition of what credentials do you have? Yes. Yeah, all.
During
The
your
limit does
time
not
at
exist.
LAUSC,
She just
even
has an
after you left
incredibly
the Los Angeles
interesting
coroner's office as a fellow, did you continue to stay in
life.
contact with the coroner's office and have relationship with the coroner's office as a supervising physician?
I continued to stay in contact with the coroner's office, and I used to attend their conferences as often as I could, not as a supervising physician, but as a physician and a graduate of their program.
During your tenure at LAUSC, did you ever become the director of any programs at
I imagine that
LAUSC?
she did.
Yes.
Does that include the director of Center for Life Support Training?
Yes.
What years was that, if you
Oh,
remember?
thanks,
I don't remember that.
The early 2000s, late 90s?
Yes,
you
that
weren't
sounds
in
about
frame
right.
if you want to
And
model
we
the
would
Launard
conduct
Tumblr.
lots of
You still
courses,
aren't in
including
frame.
trauma,
You're so funny.
life support courses.
Oh, I gotta
Did
get the opposite.
LAUSC
I'm sorry, Chad. My husband seems to want to model
Is
the
that correct vintage?
the
that
Launard.
correct?
Yes.
Sorry.
Are you now competing with Warren because he posted the thirst traps in his Launard shirt? Is this the competition that I'm now seeing?
I have no idea what that means. Are you the thirst trap, the water cup? Are you thirsty? Is that what it is?
Yes, I'm thirsty for the water cup, Dr. B. That's exactly.
As long as I'm carrying it, right?
That's exactly what I meant by that. Thank you. Chad, I will let him know you all said hi. We're going back to Dr. Russell.
incorporate a
at
quality
LAUSC.
improvement program
Yes.
within their institution?
Yes.
Did you become a director of that as well?
I'm
Yes.
sure she
So
did.
you were director of Center for Life Support
Just
Training
all the
and
things.
director of LAUSC Medical Center Quality Improvement. Is that right?
The quality improvement was for the emergency department.
All right.
Yes.
That's a
Uh,
high.
and
That's a high
Did you
volume
also
hospital.
become the director for jail medical services?
Yes.
What is the
Because all the jail medical services for Men's Central. I know way too much about this. Look at this. Massachusetts and LA, nothing but trouble. The jail services from Men's Central, and I think there's two others, all go through County USC as well. Oftentimes when I was doing search warrant duty, that would require search warrant to extricate things that people had smuggled into the jail in body cavities, but it involves quite a lot more. So I'm not surprised she was also working with jail services.
association between LAUSC and the very, very expansive jail system in Los Angeles
I know.
County?
So LA County Hospital was unique
Alan
in that
knows
they
too.
many years ago developed a jail, what they called a jail ward, which was a combined inpatient, outpatient, and ER. So there was a dedicated jail ER. And that has been in existence for probably about 70 years now. And patients that were placed under arrest by either LA sheriffs, LAPDs, California Highway Patrol, or any of the municipal agencies in
That
the area,
didn't
and I
have
think
their
there were
own
about 70 or more municipal agencies,
Municipals.
could bring their patients to the LA County Jail Ward
'Cause the
where
municipalities
the
don't
patients would
have
get treatment.
You ultimately
treatment.
became the director of that entire program, correct?
Yes.
Did you also work with the State Medical Board of California in any capacity?
Yes.
Tell us about that.
For about 7 years,
try-
I
he
worked
was trying to.
part-time for the California Medical Board as a physician assigned to one of their enforcement teams. And I did that 1 day a week, and I did my other job at the county hospital the other 40 hours a week.
So you didn't take off
That was
time from your duties as an ER physician, as an emergency physician.
She's
This
like,
was in
time
addition
off.
to you being an
No,
emergency
we just
physician.
do it all.
That is correct.
Did you hold the title of Chief Medical Executive for the California State Prison System, specifically at Corcoran?
Yes.
Tell us about that.
So I retired from LA County Hospital, and I went on to move on to the the California Department of
Prison system,
Corrections and
right.
Rehabilitation.
And what year was that?
Separate than
Did
the
you
jail
make that
system.
transition?
So 2018 is when I started for the state prison system,
Okay.
and I worked there for 5 years as director of their medical service
So you
in
were-
Corcoran.
I'm sorry. So for that prison, within that system, you were the chief medical executive for the entire agency, correct?
That is correct.
All right.
For the entire prison.
For the state
Understood.
prison system,
Um,
separate from the LA County jail system,
Are you
the,
board certified
the California state prison system is also massive.
in emergency medicine?
Yes.
Are you a member of the National Association of Medical Examiners?
Yes.
Are you a member of the American Academy of Forensic Science?
Yes.
So, okay, she's a forensic pathologist, a coroner, a medical expert, a former cop, like all the things.
Do you have any publications in the area? And I'm going to be very specific because you've been relatively widely published. Is that right?
Some people would say yes, some people would say no.
She's like, how do you define widely published? The academics that don't work in the ER might say no, but those of us working folk that have published more than a few, yeah, widely published. I can't wait to hear what she says.
More than a couple of publications
Correct.
and peer-reviewed journals, correct?
Yes.
I want to focus your
'Cause of
attention on
course she
animal
has.
injuries. Have you been published in the area of animal injuries specifically?
Yes.
How did
Do you
they find
recall
each
those
other?
publications?
Yes, they had to do with law enforcement dog bites.
Did you draft an article or co-author an article called
Which would
Managing
be-
Law Enforcement Dog?
If you're looking at an area because she has worked in the prisons and because she has worked at LA County USC in their jail ward, I imagine one of the things they see quite frequently are in custodies that have dog bites, because that is not uncommon for with the 70, 80 plus agencies that would come to her. So it's not surprising to me that she would have not only a lot of experience, but would have seen a lot of different types of dog bite injuries based on her job. That makes so much sense. All right, let's go.
Bites in the ER.
Yes, I was a co-author.
1996.
Sounds right.
And that was a peer-reviewed article,
Yes.
ultimately published,
Yes.
and ultimately
from a
available to be
treatment
cited by
perspective-
other doctors and studied by other doctors, correct?
Correct.
Did you also author or co-author an article entitled Law Enforcement Canine Dog Bites, Injuries, Complications, and Trends?
Yes, I did.
Was that in 1997?
Sounds right.
Was that also peer-reviewed?
Yes.
And that publication was also available for other physicians
Some of those
throughout
bites are
California and throughout the country
wild.
to refer to for the study of animal bites and dog bites, correct?
Dog bites. Yes.
Dog bites. Concerning animal injuries, during the course of your professional experience, how many patients have you seen, diagnosed, and or
Oh, Allison,
treated
me
with
too.
animal injuries, including dog bites and scratches, if you had to estimate?
Many hundreds.
Would you say it's over or under 1,000?
I would say it's over 500. I don't know because we didn't keep really good records back in the earlier days.
But it's safe to say you've seen hundreds and hundreds and hundreds of dog
Didn't the accidents guys, like, wasn't it a handful? Right?
bites and scratches.
Yes, in my 29 years at LA County Hospital, yes. And my dog bites I took care of, and dog bites that the residents took care of. Yes.
Janet,
And you've even
1010.
published articles
Absolutely
and
agree.
studied, not just seen them, but studied dog bites and dog wounds, correct?
Well,
Yes.
and the treatment of them. studying the treatment of them
Have you
is
qualified as an expert previously in other courts as in emergency medicine?
completely
Yes.
appropriate
Have
in
you
this
qualified as an expert in other courts in forensic pathology and wounds?
area.
Yes.
Has that been in both state and federal court?
Yes.
Right.
Doctor, were you asked to review certain materials related to this case?
Yes.
And that was in furtherance of coming to, if you could, come to an opinion or a conclusion about injuries to the victim in this case, a person by the name of John O'Keefe.
Yes.
What did you review in anticipation of your determining whether or not you could come to an opinion or a conclusion?
So I reviewed hospital
The
photographs, autopsy photographs, an autopsy report, grand jury testimony from the medical examiner in this case. There may be some other.
Based on this,
I just want to ask about that. Do you have notes with you as to what you reviewed?
She's like,
No.
notes?
Okay, so when you say that,
She's like, why would I have notes? I have a brain. Ma'am, I would need notes. My brain does not operate. But I imagine she's like, why would I need notes? I just know.
it might be other, you don't,
Well, if
if he tells you what you reviewed, you'd know it.
I would recognize it.
All right, but I want to hear it from you. You
Oh, I
you
see.
don't know of anything else
Okay.
that you've reviewed? This is sort of important, Mr. Jackson.
Okay.
Can you think of anything else, doctor,
No,
besides
autopsy.
these?
Autopsy photographs, autopsy report, neuropathology report, toxicology report, and the grand jury testimony.
okay, so as you recall, the items that you reviewed include an autopsy report by Dr. Scortibello, correct?
Yes.
A neuropathology report by a doctor named Stonebridge, correct?
Yes.
Toxicological reports associated with the autopsy?
Yes.
Grand jury?
The court just told Alan she wanted the judge just told Alan she wanted this expert to go through this. And Alan's like, yeah, okay. And then went exactly back to what he was doing.
Transcripts from Dr. Scortibello?
Yes.
Photographs of evidence items, including a gray sweatshirt?
Oh, yes. Yes.
And autopsy photos that were taken attendant to the actual autopsy?
Yes. And photographs that were taken in the hospital. And I reviewed the hospital ER record also.
So in addition to what you just listed, there's also hospital photos separate and apart from the autopsy photos, is that correct?
Yes.
And those hospital photos showed the injuries to Mr. O'Keefe's arm, is that right?
Yes.
And you also reviewed emergency room records that are attendant to his initial acceptance into the emergency room on January 29th.
She has like the
2022.
wildest,
correct.
most specific combination of work experience
Based on
to make her the
review of
perfect
all
witness
those
for this case.
materials,
It's
were
just
you able
wild.
To confidently
You never
come to any
know.
conclusions or opinions about the nature of the injuries suffered by John O'Keefe, specifically as they relate to John O'Keefe's right arm.
Yes.
What is your opinion and conclusion concerning those injuries?
Those injuries appear to be consistent with an animal attack.
Can you be more specific in terms of the type of animal, or are you relegated to simply an animal attack?
Well, they are consistent with a large dog attack. There's a combination of both what I consider bite wounds and scratch wounds on the arm.
I want to hear her talk about the clothes too.
There were also some puncture wounds in that shirt.
Yep.
And are the
So I'm sorry, puncture wounds in the shirt?
Yeah,
Puncture
there were
holes
punctures in the shirt. There
Um,
absolutely were.
And on what do you base the opinion that the injuries are consistent with dog bite or scratch marks?
Well, the patterns. There are several patterns of parallel wounds that appear to be superficial scratches that could have been caused by nails or could have been caused by teeth. There are different angles on the arm and different locations on the arm, but they're generally oriented in a specific direction. And there's also an area, the distal forearm, which is close to the wrist, which shows what I believe is an arch area of teeth marks.
And what's the significance of the arch area?
Well, so the arch would be the front area of the jaw of the animal, you know, or the dog in this case, where the teeth tend to be close together and curved. There's a curved pattern to the configuration of the teeth.
Ellen, I know that Nintendo Direct was today. Have they announced the new Switch yet? Because I know that's coming, but I am very excited. I love Zelda. So thank you. I know I've missed this trial, the 8 weeks of our lives that we have spent here together. We have, you know, Apple's WWDC, Nintendo Direct, and more. They are going to pull something up with their digital expert. I'm going to zoom. As they are looking to pull things up to show her, or they're just going to approach with the printouts.
You describe whether or not you recognize
the media is sitting in the jury box.
Yes, I have.
Is that part of what you reviewed and
I'm waiting. Should we wave to the media pool? Are any of you watching YouTube? Hold on, I just want to see. Or just wave to ourselves. I'm teasing.
First, can you describe whether or
Minimally.
not you recognize what's depicted in that photograph? Have you seen that photograph before?
Yes, I have.
Is that part of what you reviewed in coming to your opinions and conclusions?
Yes.
What is that a photograph of?
So this is a photograph of the decedent's arm near the elbow. And do you want me to describe what it shows?
Yeah,
Briefly,
sure.
an
Okay.
overview of what
Yeah, and it shows wounds.
Okay. Your Honor, I would ask that that be marked as next in order of evidence.
All right, so for this voir dire, we'll have separate evidence, right? Is this an exhibit number in the trial already?
It has not been marked yet, so I'm fine with
Identification.
starting over sort of for the purpose of the voir dire process. How are the purposes to it?
So this will be a separate voir dire with separate exhibit,
Mark it
yes.
for identification.
So it's going to be exhibit 1?
Yes.
All right, they're marking these. The reason they're marking them separately is so if there is an appeal on any of this, it's very clear what they're looking at in court. Remember, the appellate record only gets all of the documents. So the appeals court doesn't go back and watch this on YouTube or whatever. So they need to know exactly what's being looked at if this ever went up on appeal.
I want to move this along.
Yes,
This
same.
has been marked, but I think
Hold on. Okay.
I'm so sorry. This one of the three has already been marked, but if, just for consistency, I'd rather mark it additionally for voir dire. Yes.
Need a separate record for the voir dire.
May I approach?
Yes.
And the reason he asked her about her experience with accident reconstruction, and I don't know if you would be able to find another medical doctor that's also worked in
And
law
if you
enforcement.
tell me the
that
exhibit
also
numbers
worked
that
at such
they
a
are.
high volume trauma center, is because he is going to want to ask her at some time. So a car taillight versus dog. What do you think?
So you're putting these in now? There's no objection, Mr. Lally?
For purposes of this, no.
Okay. So we'll mark these now, but
May I approach?
yes.
The one with the label 2858 on the bottom has previously been marked in the trial.
But what I want is the exhibit number at the trial.
I'll get that for you.
All right, we're going to zoom as they're trying to figure out which exhibit this is, because there are 630
And it-
exhibits in this case so far.
Also in evidence, you said?
2 of the 3 have not been marked. I'll as soon as that court reporter is ready.
She's ready.
May I just establish the foundation?
Yes.
The following 2 photographs that I just showed you, Doctor, do you recognize those?
Yes.
Did you also review those in terms of furtherance of coming to your opinions and conclusions,
Yes.
do they also appear to be different photographs of John O'Keefe's arm?
Yes.
I would move for the admission of both of those, Your Honor, for purposes of voir dire.
Ms. Jessica,
There's
I
been
bet
no
they would.
objection to them, so they're in. They've already mocked.
I just need to know which one's 2 and which one's 3.
Malinois are feisty when they are working
May I
dogs.
approach?
Yes.
Feistier, in my experience, than the shepherds, but I was not a handler. I just had friends that were handlers.
Okay, that's. With court permission, may I publish
Yes,
Exhibit 2 for voir dire?
yes.
In one of the jurisdictions I worked with, we had multiple officers with the same last name, and one was a
Is this a photograph?
patrol
of the,
officer who did a lot of DUIs.
John
One was a
O'Keefe's arm?
dog handler, so it was
Yes.
dog
Is this
last
one of
name
the
and
several
DUI
photographs
last
that
name to
you,
keep them
reviewed and coming
separate.
to your opinions and conclusions?
Yes.
I want to ask you a couple of questions about this. There should be a laser pointer on the desk.
Okay.
Can you explain for the jurors what it is about the
Yeah.
injuries that assisted you in coming to your opinion and conclusion that this is from an animal attack?
Okay, there's several patterns here. So, for instance, let's look here, right near the elbow, the exterior part of the elbow. There's these 2 linear marks, which appear to be from upper teeth, and 2 punctures below those, which are superficial, meaning they didn't go very deep into the skin, but they appear from the lower teeth. So that's one pattern. There's another pattern close to the shoulder, which shows parallel marks, these 2, and maybe a third one in the middle, parallel marks that are oriented at a certain angle. And these are superficial wounds, which are consistent with teeth marks.
Would
They
you
also
define
could
them as
be
abrasion?
possibly consistent with nail marks, but
With what?
nails from
marks?
claw, yes.
All right.
We have some more here, similar from obviously different teeth involved or different claws, and then down here, closer to the wrist, we have an unusual pattern of at least 4 striations, the way I see it, at least 4 striations that I believe are caused from the teeth towards the front of the mouth, near the arch. It appears that there's an arch pattern here. So,
In a dog attack or in an animal attack, in your experience, and we can take this one down.
I ask about the abrasions because of the officer's
Just,
testimonies.
let's cover the ground on the 3 exhibits that we've already marked.
All of them.
And take a look at Exhibit 1.
We're going to look at numerous pictures of the arms, but I think that's probably all we're going to see.
Is this just a
I think that's all we're going to see of the
Is this just a close-up of the
victim
same injuries?
today.
yes.
And do these appear to be consistent with
At
what you
least
just
those are
testified
measured.
to in terms of either teeth or claw marks, especially as it relates to the area closest to the elbow?
Yes.
All right. And then looking at Exhibit 3. May I publish?
Yes.
Is this a close-up view of the area closer to the wrist that indicated those parallel, you used the word striations?
Yes.
All right, and these appear to be taken, attendant to the autopsy as opposed to the other photograph, Exhibit 2, that was taken in the hospital. Is that right?
That is correct.
All right. And would the time difference account for the slight change in the nature of the wound?
It could.
Photograph of the wound, I guess?
It could, or different technique, yes.
Okay. Let me take this
Right,
down.
or different technique of photography.
Did you take into consideration the lack, in coming to your opinion and conclusion, the lack of other injuries, for instance, fractures, broken bones, or deep bruising, soft tissue injuries?
Oh, yes.
How did that play into your opinion?
Well, so of course I considered, what else could have caused these wounds?
Of course.
And before coming to my conclusion. And
this expert strikes me. Chat, tell me if you agree or disagree. This expert strikes me as someone with deep intellectual curiosity. So I wouldn't be surprised if when looking at it, it's not, these are animal bites. It's, what could these be? What else could these be? What else could explain it? What else is there? What else isn't there? I imagine the thought process went beyond just, okay, it's dog bites. So.
And so I wanted to rule out other things, and there were no significant major bodily injuries that, outside the head. There was nothing, there were no fractures of the long bones, the chest, the pelvis, the arms. So yeah, so having seen hundreds and hundreds of car accident victims and people hit by cars, I ruled that out very quickly.
Okay. And in terms of the injuries that you did see, especially as they're attendant to the arm, based on everything that we've discussed today, is it your opinion, based on a reasonable degree of scientific certainty, that those injuries are consistent with an animal attack as opposed to a motor vehicular pedestrian incident?
Yes.
Thank you. That's all I have.
Lally.
All right, Mr. Lally.
Good morning, ma'am.
Yeah, that
Morning.
face kind of says
Take
it
it back
all.
to, you were talking about
He was just like,
police training that you had received when you were in the academy or while you were working with the police department here in Massachusetts. Is that right?
Yes.
Okay, what kind of training or what did that training consist of?
Well, I attended and graduated from the Standard Police Academy at that time. And then I took additional courses that were offered from the Massachusetts Criminal Justice Training Council. And these were taught generally by experts in their fields. And they were on a variety of subjects that are listed in my CV, included, the hit and run accident investigation,
wait, so you took the same class? Perfect. You're an expert in that too. I know you probably haven't done it in like 30 years, but
forensic
potato.
Doctor, in reference to your training as it pertains to hit and run accidents, what did that training consist of?
Oh, well, mechanisms of how accidents occur, mechanisms of how to determine, what vehicle was involved in an accident. I don't, it was a long time ago, but
I imagine her students learned quite a lot
determining
from her in the ER.
If people were struck by vehicles, what vehicle was involved, or if there was auto versus auto accident, what vehicles were involved.
And I don't mean to belittle this training whatsoever, but is it fair to say that that was relatively rudimentary training that you received in the academy?
First of all, she said that training was beyond the academy. And Lally, is what you want to do attack the training? Because she said that was beyond from the Judicial Council, not at the academy. I said that weird. But is that really what you want to do? Because remind me again, Lally, the training of your expert. Remind me. Just remind me one more time. Mm-hmm.
Probably, I would not. Yes, okay, probably. If
You don't have any training in crash reconstruction or anything like that, correct?
That is correct.
And am I correct in you indicated that you're board certified in emergency medicine? Is that right?
That's correct.
And so you're not board certified in forensic pathology or anatomical pathology or any kind of pathology?
That's correct.
And the last time that you
Lally?
worked as a coroner, when was that?
Last time was in 1995 when I was doing autopsies for the coroner's office. I have since, though, consulted on some cases from the LA coroner's office.
What, about 30 years ago? Is that about right?
For autopsy, yes.
Now, have you ever testified in a case in which either Mr. Jackson or Attorney Little were counsel?
Not that I'm
That's
aware
a
of.
good question.
And when was it that you first were contacted in reference to this case?
The first contact was May 15th.
May 15th of what year?
May 17th,
How did
excuse
that
me,
happen?
of this year, 2024.
How?
Yes.
Mid-trial.
And you went through a list of things that you were provided and you reviewed, and you mentioned hospital photos, correct?
Yes.
Autopsy photos, is that correct?
Yes.
An autopsy report, is that correct?
Yes.
Grand jury testimony from the medical examiner, is that
And again, her testimony as to when she was contacted matters because it goes to, it goes to when the defense disclosed that she would be testifying. At some point, I'll be fascinated in the story of how this all came about. And again, I have to wonder, and this is purely me wondering because we've seen it in many trials. Is this a case where this case being high profile allowed these two to come together and say, oh, hey, I know a lot about this. I'm just very curious. But anyway, let's keep going.
correct?
Yes.
A neuropathology report, is that correct?
Yes.
Oh, Lally's determined to
Pathology
piss
report, is
everybody
that
off.
correct?
Yes.
And then I think you also remembered some photos of some clothing items, is that correct as well?
Yes, a shirt. And
Anything else?
yeah, hospital ER record.
Hospital ER records?
Yeah. Yes.
Anything else that you can think of?
Lally, that's a lot.
No.
Did you ask for anything else to review?
No.
Were you told of any other material that was available for your review that you weren't then given?
Well, I requested that that I focus in on the wounds, so I didn't ask for a lot of material in this case.
Because
fair
of
to
the
say
wounds.
that you were looking for anything and everything, material to the wounds that you were asked to look at, correct?
Please say that again.
Sure. Fair to say that you would want to look at anything and everything that was related to the wounds that you were asked to look at, correct?
Yes.
And so, did you make any specific requests as to what material you were provided, or were you just handed some material or forwarded some material and you looked at what you were given?
No, I requested that I have the autopsy photographs, the ER records, the ER photographs. I requested those.
Now, you mentioned some articles that you had written that were published back in 1996 and 1997 related to dog bites. Is that right?
Yes.
Are those publicly available articles?
Yes.
And in those articles that you wrote, you were talking about law enforcement bites, correct?
Yes.
No, dog bites.
Law enforcement canine
No.
bites.
Yes.
Typically,
Law Enforcement Bites is going to become a book series, but no canine bites, Lally.
involved what people call sort of a bite and hold technique. Is that correct?
Yes. Yes.
Oh, he
Is
knows
there a
about her
difference
research.
between,
Bite
your
and hold is
experience
different.
and the hundreds
Interesting.
of dog bites that you've seen, is there a difference between what you would observe from a dog bite from a law enforcement canine versus just your domesticated dog?
Well, yes. Now, the study, one of those studies was over 700 dog bite wounds, and there were two techniques used
lot.
at that time: bite and hold, and later on, bark and hold, or bark and alert, or something of that nature. So there are different techniques, but yes, to specifically answer that question, which was, are they generally different from regular domestic dog bites? Yes.
Now, did you write a report in regard to your opinion that you testified to here today?
No.
Why not?
I don't think there was much time, and I didn't know if I was going to be actually
Right.
testifying.
Why
How
would
long
I?
would it take you to write a report?
I wasn't asked to write a report, excuse me.
Were you asked specifically not to write a report?
No.
Now, at any point in time, did you ever look at anything related to Mr. O'Keefe's head injury?
Oh, yes.
So you reviewed reports in relation to that, correct?
Yes.
Do you have any opinions as it pertains to that?
I would rather defer to the pathologist and neuropathologist on that.
Fair. This is what I love about a real expert, a good expert, a fair expert. That is not my area of expertise. I would defer to the neuropathologist on that I am not a neuropathologist. It takes quite a lot of awareness to know what you don't know. And she's like, this is not my shit. Great. Well stated, ma'am. Also, how are you not sweating in that courtroom in a jacket and what seems to be a long sleeve blouse? Lally is stumped because you just
So who contacted
answered
you about
that that's
this
not
case?
your stuff.
I contacted a district attorney that I had worked.
Oh, now we're going to find. Wait, did you contact somebody in the LA office to contact Alan because you saw this playing out? Oh, we're going to get the tea. Lally, chat. Thank Lally for asking this question. Because I want to know too.
So who contacted you about this case?
I contacted a district attorney that I had worked with in the past. We were discussing a different case, a case that I autopsied in 1995.
Oh, cold case.
And I mentioned that I heard that there was a case in Massachusetts that might have been being handled
They were
by one of his
chatting.
colleagues, his former colleagues, and that there was an issue of whether something was a dog bite, and that I might be able to help in that case.
And they said,
To
let me bring
clarify.
Alan.
And so
Who are you working a case with? I just want to know.
when you were provided this material, what is it that you were specifically asked to do?
Hold on.
To
Who's
look
working a
at the
1995 cold
wounds
case?
and the reports and the materials that were sent to me and render an opinion.
And so before you
I'm-
had even
yes,
been
I'm
provided
texting.
any material,
3
before
seconds.
you had even looked at anything, you had already heard information related to there being a dog bite involved in this case, correct?
I had heard that there was a controversy, that there's some certain wounds could have been a dog bite versus perhaps inflicted by a motor vehicle. That's what I had heard.
So what I'm really trying to get at, Doctor, is sort of the timeline. Okay, so you hear about this, when was that?
Sometime just before May 17th.
Are you watching
Sometime
on
just prior to
YouTube?
that,
Because
you
we
hear
love you.
about
You're
some
very welcome here.
controversy in a case in Massachusetts involving a dog bite. On May 17th, you get reached out to by who specifically?
His name is John Lewin. He's an attorney in the
way! Of course it's
LA District
Lewin.
Attorney's Office.
And then who did you talk to after that?
I reached out to him.
Hi, John.
I said I might be able to clarify. And then he reached out to Mr. Jackson, I believe, and then Mr. Jackson contacted me.
Of course it is.
And not asking specifically anything you spoke about, but at some point, the discussion came specifically to dog bites, correct?
He sent me the materials.
Yes, for all of you in
He
the
asked me
chat,
my opinion.
for all of you in the chat that are asking, Lewin did the Durst prosecution. So it's a big office, but sometimes it's a small
Mention
world.
the materials, asked you your opinion. When did you provide that opinion?
Of
Probably
course it
the
is.
next day. Yes, I know it was the next
Because
day.
Lewin would be
The
like,
very next day on May
OT.
18th, you provided an opinion.
Yes,
And was that opinion provided in a written fashion, orally? How was that provided?
orally.
So you reached
Can we
out,
just
or
can we just say verbally from now on? Can we just say verbally from now on?
to someone shortly before May 17th, spoke to Mr. Jackson on the 17th, received all the material.
Angie, I don't.
and
I
then
just
had
know
an
people.
opinion by May 18th.
Yes.
I think
You didn't
everyone
write
at the
any of that
LADA's
down.
office knows
No.
Lewin, though. That's not just me. And I
Now,
definitely don't
beyond the
know him as
materials
well as
that you were
others do.
provided, what else were you told about the case?
Have you all watched Jinx?
I was told that the victim was a police officer. The decedent is a police officer. I was told that the defendant had been charged, and
We're in the
I
middle
was
of
told
trial.
that that there was a controversy about whether or not these injuries had been caused by a motor vehicle. And I was also told, and I read in the medical record, that the decedent was found outdoors I believe in the snow and hypothermic.
Now, in regard to what you reviewed, you didn't review any investigator.
Ma'am, this is what we know. Can you explain what you think? Here's all the information. That's how a lot of experts go.
Reports, is that correct?
That is correct.
You didn't review any witness statements, is that correct?
That's correct.
She
You didn't
looked at
review any lab reports as far
She
as
looked at the injuries.
from the forensic lab or
basically what-
anything like that.
I reviewed the toxicology report.
Beyond that,
the
any
victim's
other-
talks. Or the
If it
defense
was
talks?
part of the autopsy report, I reviewed it.
You reviewed everything attendant to the medical examiner's file, is that correct?
Yes.
But nothing from
Autopsy.
the lab beyond that?
ER.
I
Close.
don't believe I did.
Now, this first instance, when you say you heard about it, how did you hear about it?
Well, I believe it was via a
News.
headline that I received in my email from the Boston Globe headline.
The Boston Globe has been busy.
Yeah, it was some kind of there was some kind of interesting case, and I got it as an email and I looked into it.
It is an interesting
was that?
case.
Well, that was that week in May, just a few days before May 17th.
You subscribe to the Boston Globe online?
I did at that time.
You don't
I have
anymore?
not renewed it.
How long had you been a subscriber to the Boston Globe?
I'm going to allow it.
I mean, she went to UMass. She went to
Probably
MIT,
a
Lally.
year or 6 months, 6 months to a year.
There was never any headlines or anything else that you saw about this prior to that week just before
Not that
May
caught her
17th?
attention.
Not that I paid attention to.
Right.
I have nothing further.
Anything further, Mr. Jackson?
Nothing further.
All right, so since this is a voir dire, I get to ask questions, doctor? So
Oh, yes,
I
okay.
just have a couple of questions for you. I don't think I really heard you. So could you tell me again what your opinion is and to what degree you hold that opinion?
Yes. These
I have not heard a single one, not a single one of the state's experts give a degree of certainty with which they hold the opinion, Your Honor. I am just pointing out that if the state had asked their accident reconstructionist on redirect yesterday to what degree of certainty he holds his opinion, he might have started to cry. So I don't know why we're doing this with this woman, but all right.
injuries in the arm are, my opinion is that they are the result of animal bites or scratches.
And do you know what kind of animal?
Oh, yes, most likely dog, large dog. And I'm very reasonable, very sure to, what's the word I want? Medical
reasonable
certainty.
medical certainty.
Very
All right,
high
so
degree, high degree of medical certainty.
reasonable degree of medical certainty.
Yes,
Why
definitely.
are you being condescending?
Okay, and another question. So I received information that you also viewed all reports associated with Chloe, a dog's prior bite history. Did you review those?
No, I don't recall ever seeing anything like
That
that.
you also reviewed
I think that might have been a different
the
expert.
UC Davis DNA testing results submission forms?
No, I don't recall seeing them.
Did the defense have another dog bite expert?
Okay, any follow-up, any questions based on my questions?
Not for the Commonwealth, no.
No, Your Honor.
All right, you are all set, doctor. I don't know yet whether you'll be testifying.
Okay.
Okay, we'll try and.
Ma'am.
Are you going to be around for a few days?
No.
She's going to go back
We'll
to
let you know as soon
California.
as we can, okay?
Okay.
Ah.
Okay.
Thank
All
you.
right. Thank you.
And this woman is not the one to start fussing with, Your Honor. All right, let's see what's next.
So I would like to hear argument on this witness before we hear the other
We're going to hear the
witnesses.
argument. All right.
So And Ms. Giannetti, I asked you the other day whether she reached out to you or you reached out to her, and you said there was an intermediary.
John
But
Lewin.
my concern was whether she came out of nowhere and reached out about this case, and that seems to sort of...
It wasn't Mr. Giannetti, it was me.
Witnesses are allowed to reach out and say, hey, this is my area of expertise. We saw rebuttal witnesses in the Depp Heard case do it. They have to be valid witnesses. They can't be, someone who has no expertise in this and is like, Your Honor, I was bitten. This is not me. This is hypothetical. I was bitten by a German Shepherd once, and it looked exactly the same. So I can come and testify. They have to be experts. She's clearly an expert. So it doesn't really matter how the defense found her, but it concerns the court. Let's hear her concerns. I mean, I have concerns about some of the experts in this case too, but she's not one of them.
There was an intermediary, but my concern was whether she came out of nowhere and reached out about this case, and that seems to sort of...
It wasn't Mr. Giannetti, it was me.
Okay. All right. So the question I asked was answered pretty much by this witness, whether she saw something and decided she wanted to come forward. All right. So
I don't think that excludes her as a witness. She is working a case with another district attorney, a former colleague of Mr. Jackson, talked about the case, reached out to Mr. Jackson and said, this is my history.
the Commonwealth's motion, what are you asking me to do? Again, I found a violation of Rule 14. And there are two concerns here, the competency of the witness's testimony, how much she can testify to, whether she should testify at all. What is it you're asking me, Mr. Lally?
He's asking you to exclude
Your Honor, I'm
the
asking
witness.
that the witness be excluded from testifying at the trial for the violation of Rule 14, specifically, I believe it's Rule 14A6. This is a witness, as the court picked up on, that reached out, albeit through an intermediary, with reference to just sort of discovering or coming upon this case in several weeks into the trial. It is concerning given the fact that the witness represented that she had a subscription to the Globe Online, received word of this, and the first time that she had ever seen it or it had grabbed her attention was in that first week of May when, as the court is well aware, there's been widespread media coverage, particularly through the Boston Globe, for years at this point. The limitations of the testimony, it's also concerning because the disclosure from counsel indicated, again, as the court had noted, I didn't want to get into too much as far as for purposes of this voir dire, but there was additional material that was indicated in the disclosure that the witness had reviewed, including the UC Davis related to the canine DNA or the lack thereof, as well as, forgive me, the dog bite history of that specific dog, which also, I would note for the court, includes photographs of what a dog bite from that specific dog looks like. And that specifically apparently was not provided to this witness, who's then...
Are you going to go back to 1996 and undo her peer-reviewed publications about dog bite injuries, though?
And opining on, inferably at least, that that dog was the cause of these particular injuries. However, was not shown specifically anything to do with that bite history as far as by way of reports or photographs. So that juxtaposed or coupled with
I think it's better that she wasn't shown the
immensely
dog
late
bite
disclosure.
history.
I mean, we're talking about at least
Well,
the
now
6th
you
week
know.
of trial by the time this witness is even mentioned, not on the defendant's witness list, not mentioned at any point in time during the pendency of the case, and then sort of pops up in the middle of May, and to the point that limited amount.
He's taking his cues in argument from what the judge said to him, which is what you're supposed to do, but he's taking his cues in argument from what the judge said. The judge is clearly skeptical at this point of this witness. Trial is dynamic. Lally has had a chance to examine, and it's not as if this is a completely new defense theory. It has been known that the defense has argued that these were dog-related injuries to the arm, and that's been known for quite some time. And it goes to rebut the fact that their expert testified very clearly that those were scratches from a taillight. So they're allowed to rebut that testimony.
Amount of material or information that's provided by counsel as far as disclosure or opinion doesn't come until today. So for all those reasons, Your Honor, the Commonwealth is requesting that her testimony in its entirety be excluded from this trial.
Jackson?
Your Honor, exclusion is the highest form of punishment. It's the highest form of sanction that
Yep.
the court has available to it. Just to put a fine point on it, it is a dire remedy. And I know the court has mentioned 2 or 3 times, I'm finding a violation of Rule 14. That sounds as if
The court decided.
is suggesting or has inferred that
The court
we did
ruled.
something wrong.
Yes. The court ruled at the beginning of all of this, Alan, that you violated Rule 14 by not disclosing this expert in a timely fashion. The court ruled that at the beginning of this hearing. Twice.
We didn't do anything wrong. Because the court
Yeah, you
learned.
disagree with her
I
ruling,
didn't
but
reach
she
out to
ruled
her.
that.
She reached out and said, hey, look, I've got some experience with this.
I asked you that the other day, though, and I was told that you reached out to her through an intermediary. I wasn't told she reached out to you through an intermediary.
I don't know that there's a difference. I mean,
What I was trying to
The court sees the difference, whether you reached her through an intermediary, meaning you knew of her expertise, or whether she saw this case on TV and reached out to you, which seems to be what the court is concerned about.
get at, is this somebody who read about this case and said, I want to be part of that? That's what I was trying to get at. I think it was pretty clear, Mr. Jackson. Go ahead, continue with your argument.
okay, I did not misrepresent anything to the court.
I didn't
take
say
offense-
that.
I take offense at the court's tone that yes, you did say that. You just said that. You said,
Okay.
I just heard the testimony, and it's not.
We're going to back up because now he's pissed. There is definitely tone.
Exclusion is the highest form of punishment. It's the highest form of sanction that the court has available to it. Just to put a fine point on it, it is a dire remedy. And I know the court has mentioned 2 or 3 times, I'm finding a violation of Rule 14. That sounds as if the court is suggesting or has inferred that we did something wrong. We didn't do anything wrong. As the court learned, I didn't reach out to her. She reached out and said, hey, look, I've got some experience with this.
I asked you that the other day, though, and I was told that you reached out to her through an intermediary. I wasn't told she reached out to you through an intermediary.
I don't know that there's a difference.
There is.
I mean,
What I was trying to get at, is this somebody who read about this case and said, I want to be part of that? That's what I was trying to get at. I think it was pretty clear, Mr. Jackson. Go ahead, continue with your argument.
okay, I did not misrepresent anything to the court.
I didn't
take
say
offense-
that.
I take offense at the court's tone that yes, you did say that. You just said that. You said,
Okay.
I just heard the testimony, and it's not what I said the other day. I know a person in Los Angeles DA's office. I received a text message from that person saying there's someone who reached out to me who said I might be able to elucidate on this
They were
controversy
working on
concerning
another
the dog
case.
rights. I then reached out to her. So when you asked me who reached out to whom, I reached out to her through an intermediary, my friend in the DA's office back in Los Angeles County. I was Mrs.
So maybe it wasn't clear what I was looking for. I think it was clear. But go ahead, continue with your argument.
He became aware of her because she made herself known, but she didn't call him. He called her because Lewin texted him. Fine.
On this.
My point is, Rule 14 requires a sanction if, in fact, the attorney has done something wrong. In other words, it connotes the idea that we're doing something by actively hiding evidence or holding back evidence or not providing evidence that you know you're going to use at some point in an effort to take a tactical advantage. And the sanction for that is exclusion. I've never met this woman. First time I laid eyes on her was during the process after she flew out here to engage this voir dire process. She indicated I could potentially provide some information about
Based
this
on her
controversy concerning
background,
dog rights. I
training.
then sent her materials. I talked to her. I sent her materials. I found her to be incredibly credible. I found her to be experienced, and I found her to be knowledgeable in this very specific area, which is rare. There's not that many people who have published, doctors who have published in the area of dog bites specifically. So I thought it makes sense for me to reach out to her and talk to her, which is exactly what we did. And within a couple of days, literally, you could almost count it by the hours of me receiving her information, we then had a discussion amongst ourselves. Is this somebody that we want to then present on the defense side, on the defense case? And we turned the information over to Mr. Lally. I understand that it was well into the trial, but that's not a fault of ours, and I don't think the sanction of exclusion is necessary or appropriate to punish Ms. Reed from having an experienced witness testify in rebuttal to ultimately what Dr. Scorti-Bello and the Commonwealth is going to present in their case in chief. That's what she's going to do. She's going to present contrary evidence or an alternative theory of where those injuries came from to a person. Everybody on the Commonwealth side who can elucidate about this has said those injuries come from a taillight, including Mr. Paul yesterday. We have contrary evidence, and Ms. Reed should be entitled to present that evidence, even though it came late. It didn't come late by any fault of ours, and I don't believe that the Commonwealth has made out a prejudice that they can't overcome. It's late. Obviously, Mr. Lally is a skilled lawyer. There's nothing to say that he can't or hasn't been able to prepare for the cross-examination.
I mean, he has time to prepare. That's it.
For an examination in front of the jury, and I just don't think exclusion is appropriate.
All right. So the second part of this argument, and I'll start with
Is exclusion.
Commonwealth first. So in your motion to exclude, you also raise Daubert type concerns. So, Mr. Lally, is there portions, if I permit her to testify, are there portions focused specifically on the part of her opinion where she says,
You're just telling him what you want him to argue? All right.
I guess the defense expects her to be able to say she will testify that these injuries are inconsistent with having been struck by a vehicle, road rash, or scratches from broken glass or tail-like material.
She didn't testify to that? She was not asked.
I think you have an uphill battle on that part, Mr. Jackson. But Commonwealth, what are you saying? If she testifies, what should she be able to testify to? And don't just say nothing. I want some input.
No. If the court were permitted to the doctor to testify, Your Honor, what I would submit would be permissible testimony from a legal standpoint as a factual.
So the court is trying to focus on the argument from the prosecution's motion. That's kind of the Dauber part of it, meaning this isn't based on reliable scientific evidence. So there are times you will see people arguing this is not reliable scientific evidence in a certain field. I think the identification of dog bite is different because she's a medical professional. So when you're a medical professional and you're looking at something to treat it, determining what it is to treat it is part of it. Different than areas that might be more questionable. And there are those areas in the law that are questionable. We're not talking about spiritual witnesses. We're talking about handwriting analysis or something like that. So there are areas where the underlying foundation or science of the expert opinion is in question so that everything can be questioned. But given that she is a medical professional and has published on treating and potential complications from these areas, I don't know if we have a Daubert issue here, but let's see. So it's different than scientific testimony in that it's medical testimony. So it's hard for me to see where the judge is going with this, but we'll see.
Questions in regard to that. But from a legal standpoint, I think the court could permit her to testify as to the injuries that she observed, her work in history in that area, observing prior injuries related to animal attacks and whatever consistency she believes that they have with that. I do not think it would be proper to allow.
So Lally has conceded that her identification of the injuries and where the injuries, what the injuries are consistent with would be appropriate, right? Because medical.
This witness to testify or opine anything about the inconsistency with regard to pedestrian injuries. I don't think any proper
She didn't
foundation has
testify to
been
that.
laid for there, whether it be through experiential.
She didn't give an opinion to that. She looked at those coming from a dog bite, and she also considered other factors like the lack of broken bones, like the lack of bruising. All of those things were considered when looking at this to determine if this came from a car or if this came from a dog bite. So I think she can go through that and say, this is why I think it's a dog bite, and these are the things that ruled out something else.
Knowledge in relation to that, or any sort of specialized training or knowledge, or
yes, it's a significant
anything to
sample
do with
size,
that.
700 dog bites.
Anything from a forensic pathology or anatomical pathology perspective, I think should also be out of bounds and excluded with regard to this witness. She's certainly a very experienced emergency room physician. So anything in relation to that, I think it's permissible. But as far as the experience when it comes to motor vehicle crashes or pedestrian crashes, of which the court is well aware, there are a litany of different types of interactions a pedestrian can have with a motor
Sir, have you ever driven in LA? Because
vehicle in a collision sequence.
This woman has seen a lot of collisions.
And simply saying, well, there was no injuries to the leg, so it couldn't have been a motor vehicle
She didn't
collision
say
is
that.
just plain wrong, and not backed up by science or anything else that this witness can testify to from the very limited experience she has in that realm. So if the witness were able or permitted by the court to testify,
I think the court's
I
gonna
would submit
narrow
that
the testimony.
her testimony should be relegated to simply
But that's what the defense is seeking.
what, if any, opinions, her experience, obviously, and then what, if any, opinions she draws with regard to the causation of the injuries on the right arm, as it pertains to
Lolly's kind of
consistency
giving
there. But
the judge an out, actually.
venture to guess that it's likely.
I think Lally's giving the judge a bit of an out because the thing that Lally conceded to is exactly what the defense is seeking. The thing that Lally is arguing is what he's been doing with his experts, which is taking their area of expertise and then expounding upon it in an infinitial way. So he, I think, is giving the court what she needs to say, okay, well, we're limiting this testimony. She can't testify that the lack of injuries is inconsistent with whatever. So that's not what the defense was seeking anyway.
That those are probably also going to be, in her opinion, consistent with many other causes beyond that, if she's being reasonable.
All right, Mr. Jackson.
I'll submit, Your Honor. I have no issue with.
Right. Lally conceded to what the defense wanted.
I have no issue with limiting her testimony to the animal attack issue, the dog attack issue. I didn't, as the court noted, I didn't spend any time. I think I may have asked one question that's consistent with the motor vehicle incident. I have no problem if the court wants to limit her testimony to a dog bite.
Because that's what they're calling her for.
Aspect. I wasn't planning on going into that aspect anyway. I've got another pathologist who's going to do exactly that.
But you did go through it with her, and it's
Not
on your
really
disclosure.
It's on the disclosure.
It is, but I have no problem.
It's on the disclosure. So the defense is also giving the judge room to, legal term of art, split the baby. But the defense is giving the court room to rule both for them and against them in the same breath, because I think they can tell what the judge wants to do. So her testimony can be confined to the dog bite, not to anything else. And that gives the judge room to say, okay, I've put some constraints on it. So now we can all feel like we've done something. So now it's that the disclosure has too many things in it. Fine.
Editing.
But as the defense, you've got to give the judge
the
something.
disclosure, or what the Commonwealth turned over, that she viewed all reports associated with Chloe's bite history and the UC Davis DNA testing? Why is that in there?
Because we set that in a Dropbox. We set everything in a Dropbox, and I assumed that she reviewed it. She must not have seen it or opened it or reviewed it. I didn't know.
Because we sent it.
But that's what we sent to her.
We-
Everything that's in the disclosure is what we sent.
Your Honor, we disclosed everything we sent to her like you told us to do. And now you're like, why is this in here? Well, we can't force her to look at it. We just sent it. Did we disclose too much, Your Honor? Because I thought that was the opposite of why we were here.
All right. If she's
Okay.
permitted to testify,
She
you led
has
her
to be
through
permitted
quite a
to
bit.
testify.
Today, you won't be able to. I mean,
Like what? Oh, he
she
did
struggled
absolutely lead.
with to what degree of certainty she held an opinion. She struggled to what she viewed. She didn't write a report. I have to consider all of these things too, as the gatekeeper, as to whether she can actually assist the jury. So I'm not deciding this right here. Mr. Lally, if I do permit her to testify, I will give you time to absorb this testimony and to find an expert in rebuttal for this. How long might something like that take?
Oh, Jesus Christ.
Not terribly long, Your Honor.
Really?
As far as preparation, I can't give an exact time frame on that. As far as a rebuttal witness, I'd say a week at the most.
A week?
A week from today?
Yes.
Why don't you start looking at least? All right, well, I decide I won't know until Thursday.
The court's going to let this testimony in. She says she hasn't decided, but the court's going to let this testimony in.
Sure.
All right. All right, anything else on this witness?
Submitted, Your Honor.
All right, next witness, please.
The court's
With
going to
regard
allow
to,
this in under those
Dr.
limitations.
Wolfe and Dr. Rintscher, this is a different scenario.
So this is what I think. The court, Lally, how long is it going to take you to find a rebuttal expert? I imagine that the rebuttal would just be the same pathologist and they would just need to ask about it. But the court was going to give the Commonwealth time because the court has already found that the defense violated their disclosure obligations. Whether they did or did not is a whole separate conversation. That's what the judge ruled. But I think the judge is going to allow this in. She told Mr. Lally to start absorbing the testimony and looking for a rebuttal witness if he needed one. I imagine it's just going to be their own pathologist who's going to do that rebuttal, and those conversations need to happen. But I think the judge will allow this. She indicated she's not ruling till Thursday, but her questioning is very much signaling that she is going to allow that in. So we will see what happens on Thursday. But if it's going to take them a week to get to the rebuttal case, that's next Thursday, Friday at the earliest, which means this is not going to the jury until the week of 4th of July, which is kind of what we've all been feeling in our gut anyway, isn't it?
And I'm presuming that the court is asking for a what year on their qualifications.
Well, I want to know who did what. I want to. They say we. I want to know who did what.
So is the court suggesting that I go through their entire testimony of exactly what they did? Their
Yep, that's what she
testing,
said.
Their opinions, conclusions, the bases of their opinions, conclusions.
Mhm.
However you want to do it, Mr. Jackson, we're here today on the Commonwealth's motion.
I realize that, but it's not the Commonwealth's motion to depose our experts. The Commonwealth's motion is they're not qualified as accident reconstructionists. I don't need to go, and I'm not inclined to give them a free bite at the apple to cross-examine these witnesses twice on the basis of their opinion. I will go through, I think, to the court's satisfaction. I don't think it's going to take long to figure out that they're extraordinarily qualified.
This is different
to their
witnesses.
opinions.
The Commonwealth has filed a motion to exclude, so that's why we're here. These are different witnesses than the last witness. So these witnesses, it seems, or it is my understanding that the next witnesses come from the federal investigation. The court's frustration is that the reports seem to say we. How much testimony in this case have we heard where somebody testifies as to we, and I have sat here and been like, we who? You? Not you? Someone else? Who is we? Yesterday, the accident reconstructionist was like, we, and Jackson's like, we who? And he's like, oh, the royal we. It's like, sir, what? And stuff? Are you serious? So the court is now looking at this motion to exclude as to the next two witnesses, but it seems the disclosures to the defense and the Commonwealth are the same disclosures. They're all on the same playing field. They all have the same information. So this is a different situation than the last witness. And the defense is like, they shouldn't have the opportunity to pre-cross-examine these witnesses. We've all had the same disclosures. Everyone should have to do this live. This is a different scenario than the last witness.
I don't think it's incumbent upon me to walk through their entire testimony and give the Commonwealth a free bite of the apple like it's a deposition.
Whatever you want to do. I'm not telling you what to do. Whatever you want to do.
You're going to tell Lally what to do, though, aren't you? This is kind of preposterous. As to these witnesses, this is wild. So, we'll see what happens.
Yes.
Thank you.
All right.
Very loudly into the microphone.
Hi, sir. Who are you?
Whenever you're ready, Mr. Jackson.
Thank you, Your Honor. Sir, could you please state your name and spell your last name for the record?
Daniel Wolfe, last name spelled W-O-L-F-E.
Sir, what do you do for a living?
I am the director of accident reconstruction at a company known as ARCA, A-R-C-C-A.
And tell us a little bit about ARCA. If you could explain to the court what ARCA is and what its primary mission is.
So ARCA is a forensic consulting engineering company. We have a variety of disciplines that include biomechanics, failure analysis, human factors, premise liability, crashworthiness, and accident reconstruction.
You said that
He said
you're the
biomechanics.
Director of accident reconstruction, correct?
That is correct.
Is that a specialty of ARCA specifically?
Yes, sir.
And what sort of contracts does ARCA routinely engage in?
We typically work for law firms, insurance carriers.
What about other clients?
More like
for instance, maybe it's an
Paltrow.
insurance carrier or a law firm. But what about the ultimate client, the military, Department of Defense? Have you contracted with other entities or agencies, sporting agencies?
Certainly, yes. We've done research for the military. We do player safety for the NHL. So yes, we are involved in a number of research projects as well.
And in terms of ARCA and its commissions and consultation,
So the NFL player
both nationally
safety.
and internationally, is it recognized as a leader in the area of accident reconstruction?
Yes.
We'll go to that
As the director of
biomechanics.
accident reconstruction, do you specialize in not only accident?
So they were brought in, this firm was brought in into the other investigation that is being done by the U.S. Attorney's Office and the feds. So that's where, did he say NHL? Not NFL? I thought he said NFL. Sorry, NHL, I was taking notes. So hockey. All different kinds of biomechanic injuries. So he was brought in, or his firm was brought in to the other one. So I thought he said NFL, not NHL.
Reconstruction, but human factors
Apologies.
as well.
Yes, sir.
Can you give me a synopsis of the professional
That's what I get when I'm
discipline
looking at notes,
of
not at
accident reconstruction?
mouths
What is
moving.
accident reconstruction?
Well, I think that's a very broad topic. I look at the cases that come across my desk. You know, I've been involved with pedestrian impacts, and that can be pedestrians hitting the side of vehicles, fronts, backs, getting run over by vehicles, being struck by a vehicle, then projected into another vehicle. I've dealt with your simple fender bender collisions. I've dealt with collisions that involve 60-car pileups on a highway. So again, accident reconstruction in terms of the scope for a case, it can really vary
Could be a
case
lot.
to case depending on the facts and circumstances of that case.
And when you say dealt with, are you talking about literally going into, from an engineering and a scientific standpoint, trying to reconstruct what happened, what the causal effects
trying to
were
figure it out.
of that accident, and what the results were, the resultant damage or injuries were?
Absolutely.
What about human factors? What does that discipline entail? What is human factors?
Well, to give you an
Sorry for the
example
pause
of that.
face, sir. Okay. That's the point of reconstruction. That's what I thought we were going to get with the Commonwealth's witness. The point of reconstruction is to look at everything and then say, this is how this happened. And I keep calling back to the Paltrow case because that's the best example we have of cases that we've watched together where the reconstructionist looked at how everybody ended up, looked at the eyewitness testimony, looked at what all the witnesses said and said, okay, The only way the end result makes sense is if the mechanics of this accident on this ski slope happened this way. In this case, it's very interesting that that's not what happened with the Commonwealth's witness from my perspective. The Commonwealth's witness, it seemed to come in and say, this is a pedestrian crash, figure it out. And he was like, well, it could maybe be this, it could maybe be that, versus look at all the evidence and then break it down step by step. So let's see.
So I do a lot of nighttime visibility work where, for instance, let's say a pedestrian's coming out onto the roadway at night. Maybe it's not a lit roadway and you're relying on your vehicle headlights to illuminate that pedestrian. So it's determining when.
Wait, do you do any work? I'm so curious if he does any work with autonomous driving and the kind of AI decision-making systems and the information of how cars decide what's in the roadway at night and stuff. I'm just very curious. Anyway.
Would a driver recognize that individual on the roadway based upon the headlights, if there is any artificial lighting, their clothing? And then we look at how do drivers respond based upon that scenario that they're presented with. So we know that response times are different depending on the hazard that's presented to them. So if it's a pedestrian coming to the roadway, it's a vehicle stopping in front of you. So that's the application of human factors.
And that might include everything from passenger vehicles, commercial vehicles, bicycle issues, motorcycle issues, things of that nature.
Yes,
all
sir.
the issues.
Okay. What education, training, and background qualifies you to perform the duties that you've just described as director of accident reconstruction?
Also, just to point out, and then I'm going to what are you guys calling him Crash Daddy? Is that what's happening? Chat. Responsibly. Look, the chat clearly stands competence. I get it. Competence is very sexy. I understand. You've blinded me with degrees. I get it. I married a man with a wall full of them. You know, what are you going to do? But notice the way that Alan is going through his questioning and how it's different vis-a-vis the way that the direct examinations happen with Lally. This is a stylistic choice. But this stylistic choice is, hey, tell us what you do. Tell us the cool shit you work on. Then tell us your qualifications. Don't bore me with like, first I did this and then I did this. Tell me about the cool shit that you do and then we're invested. And then after you tell me about the cool shit you do, then tell me about your background, training, experience, education. It's so much easier to listen because you know what you're looking for when you're listening. Oh, you work on this cool shit. Okay. How does your training and education relate to the cool shit? Stylistic difference, but it makes a huge difference when listening to testimony.
Instruction at Argument.
In terms of my educational background, I received a Bachelor of Science in Engineering from James Madison University back in 2012.
Oh, look, that engineering
along
degree.
with a minor in mathematics.
We knew that
some of
was
my
coming.
coursework while at James Madison included courses in physics, statics, dynamics, kinematics, material science,
We knew this was
your
coming,
typical
right?
engineering sciences.
Basic engineering shit.
Subsequent to my undergraduate degree, I then went on to the University of Delaware to pursue my PhD in electrical and computer engineering with a concentration in electromagnetics and photonics.
Sure.
Did your research area also include physics, in addition to electromagnetics,
Yes, sir.
optics,
Yes, sir.
photonics,
Yes, sir.
and lighting?
Correct.
Sure.
Are you accredited as a traffic accident reconstructionist?
Yes, sir.
By whom?
By an organization known as ACTAR, which is the Accreditation Commission for Traffic Accident Reconstructionists.
Are you trained in photogrammetry to determine vehicle crash and map scene evidence from photographs?
Yes, sir.
In other words, looking at a photograph rather than being at the scene, that is a specialty or a specific area of training that you've engaged, correct?
Yes, sir.
Are you trained in Bosch crash data retrieval analysis,
Yes, sir.
otherwise known as CDR analysis, right?
Correct.
In terms of professional associations and accreditations, are you certified by the Society of Automotive Engineers?
He's like, all.
Yes, I'm a member of that organization.
What about being a member of Optical Society of America,
Yes, sir.
Illuminating Engineering Society,
Yes, sir.
and finally the National Association of Professional Accident Reconstruction Specialists?
Yes, sir.
You're accredited by all of those organizations, is that right?
I'm a member of all of those. Yes, sir.
Have you authored peer-reviewed articles in the area that we?
I would imagine that's going to be a yes.
I've authored a number of papers in the field of physics, and one of my most recent publications was that dealing with Toyota and Lexus vehicle control history records.
Weird.
In 2021, did you author?
I'm sorry, sir. Wait, you're publishing in the area of Toyota and Lexus control records? Weird. So you didn't like go to YouTube and try to figure out what their system was?
Co-author a peer-reviewed article known as Collision,
Okay.
International Compendium for Crash Research Dealing with Vehicle Control History and Braking Issues.
Yes, sir.
Have you qualified in other courts to testify as an expert in the area of accident reconstruction?
Yes, sir.
Importantly, were you hired by the defense in this case?
No, sir.
Before this,
Alan, your enunciations sometimes are so aggressive, my dude. The defense. Were you hired by the defense? We know he wasn't. He's going to get to talk about it because the jury's not there.
morning when you walked into court, have you and I ever met face to face?
No, sir.
In terms of the commission that you were asked to undertake in this case, that have anything to do with the defense?
No, sir.
That have anything to do with the Commonwealth?
No, sir.
So a third-party agency hired you and commissioned you, or
We know who it is.
responsibility of doing an accident reconstruction.
Yeah, Alan, we're aware.
Correct.
The person to my left, the female to my left, sitting here.
Do you know who
Have
that
seen her
is?
Before?
Nope.
Right.
Do you know who she is?
Yes.
She's sitting between the attorneys at defense table. So
How many
we're
times have
aware.
you been qualified in other courts to testify as an expert in the area of accident reconstruction?
I think it's around 20 times to date.
In both federal and state court?
Just state court.
Multiple states?
Yes, sir.
Your analysis, conclusions, and opinions are completely independent, whatever they are. Those analysis, conclusions, and opinions in this case are completely.
Chad, just because we're going to have to do this every day. You can cast him in ACOTAR, but ACOTAR is the ACOTAR is the organization for the accident crash reconstruction, not ACOTAR. But y'all, I'm not going to tell you what to do.
Independent of the defense and of the Commonwealth. Have I got that right?
It's based on the evidence. That's correct.
And you're not paid by either side here in this courtroom.
Correct.
Which is a really
You and
interesting
your team were
thing.
asked to.
In this case, I
undertake a
talked about it
review
yesterday.
For purposes of accident reconstruction of the case.
Real
that's now
interesting
pending in
thing.
court. Is that right?
That's correct.
Never.
Who at ARCA was assigned to the team who ultimately would undertake that analysis?
So it was myself, Dr. Andrew Rintscher, and Scott Klein.
And Scott Klein has a Master of Science, is that right?
I believe he's got a Bachelor of Science in Mechanical Engineering, yes.
In engineering.
Correct.
All right. And Dr. Rintscher is a PhD in what area?
Biomechanical Engineering.
Were you provided and did you review certain materials?
He's not with the FBI, but chat.
The FBI!
He was involved in the federal investigation. So he was hired, or his company, the company he works for, was hired, probably not by the FBI, probably by the U.S. Attorney's Office. But either way, he's been hired by the feds to assist in the accident reconstruction because it seemed that the feds, and this is me speculating, didn't rely on the Massachusetts State Troopers accident reconstruction and sought an independent expert. So,
Materials in furtherance of your consultation.
and everyone
in this
asking,
matter?
what the fuck is
Yes, sir.
ACOTAR? It's a
Yeah,
book
just a moment,
series.
Your Honor.
Yes.
It's okay. It's okay if you don't know. Like if you know, but it's okay if you don't know.
I'd like to use my time efficiently, Doctor. I'm going to read through a number of materials that you reviewed.
All right, did you do all this shit? Yes? Great.
Before I do that, may I approach, Your Honor?
Yes.
If you recognize that.
And the state also has all of this because this was all turned
Yes,
over.
sir.
What is that? What are those 2 pages?
These are the first 2 pages from the report that ARCA issued in regards to this matter.
Do you see a list of 14 items on those 2 pages?
Yes, sir.
Is that an accurate reflection of the items that you were provided by this other agency to review in terms of coming to your opinions and conclusions concerning this case?
Yes, sir.
May I approach, Your Honor?
Yes.
Those items include the Norfolk SPDU homicide death report, correct?
Correct.
The Commonwealth of Massachusetts Department of State Police crime scene report.
I don't
correct?
know who
Correct.
got the feds involved. I don't know how they
OCME
started looking into this. We don't know
dispatch
yet.
report, correct?
We'll see.
Correct.
These are all the things
Photographs of
he
the incident location.
reviewed.
Correct.
Videos of the incident location.
Correct.
Photographs of the 2021 Lexus LX 570.
Correct.
Photographs of recovered evidence.
Correct.
Crash data retrieval report from the 2021 Lexus 570.
Correct.
Report of
I mean-
autopsy.
Correct.
Autopsy photographs.
I'm not going to tell you to not Google Akatar because they sell it at Target. So it's not in the level of spice that you can't just normally go find. So
Three-dimensional laser scan
at
data
least to me, it's
of a
not.
Lexus LX 570.
Probably tells you
Yes.
something about me.
A VIN-Link, VIN capital LINK report sheet for the 2021 Lexus LX 570.
Yes.
Expert AutoStats data sheets for a 2021 Lexus LX 570.
Yes.
And publicly available literature, including but not limited to the documents cited within the report, learned treatises, textbooks, and scientific standards, correct?
Correct.
All of those items and data were reviewed by you and your team in coming to your conclusions and opinions in this case, correct?
Chad,
Yes,
I'm
sir.
on the
And
same
I'd like
page
to
with
ask you
y'all.
one other series of questions concerning sort of who did what. Your report indicates that there were, in no small part, two undertakings, if I can ask them in terms of pillars: the damage to the vehicle and the injuries to the body of John O'Keefe. Correct?
I would say that's a fair characterization. Yes.
Okay. And I may be butchering this a bit because I'm not being very scientific, but were you more responsible for the vehicle damage or the injury damage?
The vehicle damage.
And who on your team was more responsible for the injury damage?
That would be Dr. Andrew Rintscher.
The
Obviously,
doctor.
Dr. Wolfe, in
So the
coming to your
doctor
opinions and
looked-
conclusions
the
concerning the damage to
doctor.
the vehicle, you had to consider the damage to the human being, correct, John O'Keefe?
Correct.
And
I feel
as
so
the-
bad for all the experts that have to follow the accent. It's not easy when you have to follow the accent. And Amber's Patile said this is so interesting today. We're getting into a sneak peek of the defense case, which we don't always get. So that's where we're at.
the team leader.
Oh,
in
chat,
terms
y'all
of Dr.
know
Rintscher
we're all on
coming
the same
to his
page.
conclusions and opinions concerning the damage to the human being, he also had to consider the damage to the vehicle and the interplay of the two, correct?
Correct. We work together.
I was just going to say, is that how you two and Mr. Klein worked
Sir,
together to come to the opinions?
If you were
and
to say
conclusions
get in the
that are
car,
cited
Elizabeth,
in your multi-page
how would you
report?
say it?
Yes, sir.
Thank you. That's all I have, Your Honor.
Okay.
He didn't want to get
Mr.
into
Lally?
his expert opinion. Lally's probably going to. So this expert reviewed the mechanical. The other expert reviewed the physical because
Morning.
he's a doctor. Court's going to be over early today.
Now, you went through a list of about 14 things that are contained within your report that your firm or your agency was provided with that you reviewed, correct?
That is correct.
Did you specifically review all 14 of those things, or was that done as sort of a team?
Yes, I looked through all of the documents.
So you personally looked at all 14 of those items that are listed within the report?
He's like,
Yes, sir.
Yeah, court's going to be done early today if this is how these are going to go.
You
There-
indicate that it was...
Chat, there might not be a lunch.
opinions
Court
or
actually might already
what
be
you did
done.
in this
There's not
case.
going to be a
So
lunch
you
because
were
they're doing
asked
this for 2 witnesses and then they're
answer
done.
specific questions, correct?
Yes.
It wasn't like you were just tasked with, hey, here's some facts, go do or take a look at a crash reconstruction or create a crash reconstruction. You were asked very specific questions and you tried to answer them the best you could, correct?
I don't know that there were specific questions. I think ultimately it was an open-ended question.
But related to you testified as to 2 specific areas that your firm or your agency looked at, right?
Those are the disciplines that
Avalon said, I thought there were 3 witnesses. We did the first doctor, and then this is going to go very quickly for this witness and the next witness because it's going to go like this. So they set aside an entire day to do this, but they're going to be done quickly if they are not already done in real time because I've been pausing and chatting. So this is going to be a half day. So we actually will be done pretty soon, and then we'll have plenty of time for questions. So I'm going to start grabbing questions from the chat so we have time for it.
The report
But that's what we're going to
covers,
do.
yes.
Well, you testified about some other areas of expertise as far as human factors, visibility, luminescence, things like that. You didn't do any of those things here, correct?
Wasn't part of my scope in this case.
And the scope in your case, you indicate that it was based on the evidence, correct?
That is correct.
Now, to be fair, that's based on the evidence that you were provided, correct?
Correct.
Which is the same evidence your witness was provided, Lally. Same. You only relied on the evidence you were provided. Yeah. Same with yours, dude. And it sounds like he actually might have been provided more than your reconstructionist was provided, Lally, if I'm being honest.
So as a part of the engagement with the entity that ultimately retained us in this,
careful to not say who's
due
doing
to
that
the
investigation.
confidentiality of it, only those who had access to the material to the file were allowed to review it and discuss it. And essentially, Scott Klein served as kind of another reconstruction expert to essentially bounce ideas off of and help with the review.
So for lack of a better term, sort of provided, let's say, sort of technical review of your work and Dr. Rintscher's work, is that correct?
I would say assist us with the analysis, yes.
Who reviewed your reconstructionist work? And you guys, I am grabbing your questions out of the chat.
No,
So-
so your firm and your agency issued a report in relation to what you did, correct?
That's correct.
And you've obviously had a time to review that report as far as what's contained in there factually as well as conclusions.
Am I being cranky? But does it seem like Lally's not really sure what he wants to ask?
And opinions, things of that nature.
Yes.
So is it your testimony that anything that has to do with anything factually, conclusions, opinions, or otherwise, in relation to the motor vehicle damage, those are your opinions, those are your conclusions, correct?
I would say that's fair, yes.
And again, based
And
on
the medical
evidence
stuff
that
is the other.
you were provided, correct?
Correct.
And so the facts or evidence or conclusions or opinions related to injuries to Mr. O'Keefe, that was Dr. or Mr. Rintscher's area, is that fair to say?
Dr. Rintscher, yes.
And again, that was based on the evidence or whatever he was provided, correct?
Correct.
Which would be the same materials that you had testified that you had reviewed, correct?
Correct.
Because he testified at the grand jury.
Anything further?
Nothing
Mr.
further.
Jackson? All right, so Doctor, I just have one question for you. What specifically were you asked to do?
I'm sorry, Your Honor.
He has provided the Commonwealth and the defense with their reports and their grand jury testimony because he testified at the grand jury. So they're going to know more than he's testifying to right now because they have that testimony transcript. The court might not have all of that.
What specifically were you asked to do?
So the agency that retained us gave us a
confidential.
selected quantity of file material related to this case and essentially left it as an open-ended question. Ultimately, was the evidence consistent with a pedestrian interaction between Mr. John O'Keefe and the Lexus?
Okay, you said selected quantity of information. Who selected that information?
He doesn't know. The entity?
As far as I'm concerned, it would be the Department of Justice and the FBI.
Right.
All right, and they just gave you what they wanted to give you as far as you know?
We had no say in.
The FBI just gave you what they wanted to give you. Your Honor, Lally only gave his expert the evidence from January 29th. Are you... What? Alan Jackson read in everything they were given. Your Honor, all of it.
What material was handed over to us?
Okay. All right. Thank you very much. Any questions based on my questions?
No, Your Honor.
Mr. Lally?
Just briefly, And I apologize for this. I'm just unaware. Is it Mr. Wolfe or Dr. Wolfe?
Dr. Wolfe is fine.
So, Dr. Wolfe, when you say
Dr. Wolfe is acceptable, Lally. That would be doctor.
That you were asked specifically whether or not the evidence, the limited scope that you were provided was consistent with a pedestrian collision. Were you asked sort of in general terms as far as any type of pedestrian collision, or were you asked specifically as far as biomechanically could say the injury to the back of Mr. O'Keefe's head have been caused by contact with the vehicle? How open-ended was this question?
Again, I think it relates to, is the vehicle damage consistent with the pedestrian impact, and are the injuries consistent with the pedestrian impact?
Is the evidence consistent with the pedestrian impact?
Again, the whole panoply of injuries, is that correct?
I'm sorry, what was your question?
All of the injuries.
So did anybody specifically ask you to determine whether or not the injuries to the back of Mr. O'Keefe's head could have been caused by...
No, the other witness did that. The other doctor witnessed
I don't know that they asked us specifically. Again, they basically asked us to perform an accident reconstruction and biomechanical analysis and basically tell them our findings, and these are our findings.
And in the materials that you reviewed, did you see anything in there of any...
They basically said, can you figure out what happened here? Just open. Can you figure out what happened here? That's it. Can you tell us what happened?
Sort of statement, suggestion, intimation, anything at all that suggested that the injuries or the fracture to the back of Mr. O'Keefe's head was caused by a motor vehicle?
In terms of direct contact?
Yes.
No, I don't believe so.
Nothing correct.
Does anybody
All right,
think
Dr.
that?
Wolfe, you are all...
Does anybody think that the injury to the back of the victim's head happened from direct vehicle contact? Aren't we all operating under that happened with contact with the ground? Isn't that generally what your expert said? That he was spun and hit either the ground and or a curb and or something? Is what, Lally?
All set, sir.
Thank you.
Direct vehicle strike to the back of the head. What? All right, next witness. This is the other side of the investigative team. So that last witness plus this next witness.
Ask you to be mindful of the court and step up. You're going to remain standing.
You saw this when you have the court in case down here.
So this is the third witness for voir dire. This will be the last one.
I do.
Gotcha.
All right, whenever you're ready, Mr. Jackson.
Thank you, Your Honor. Sir, could you please state your name and spell your last name for the record?
Certainly. Dr. Andrew John Rintscher, Rentschler.
Sir, your last name is Rintscher and you work in accident reconstruction. Well played. Just well
Sir,
played.
What do you do for a living?
I am a biomechanical engineer and accident reconstructionist.
In what area of the country do you live in?
I live in Pittsburgh, Pennsylvania.
What is your title
Sir, do you ever do ski crashes? Because we're fascinated by those too.
currently at your company?
I am a vice president and director of biomechanics for the Midwest Division.
And what is the name of that company?
It's called ARCA LLC.
And what is the main mission of ARCA? What does ARCA do?
So ARCA is a engineering consulting company, and we have several different types of engineers, biomechanical engineers such as myself, accident reconstructionists, mechanical engineers. We look at crash worthiness, safety of vehicles, and other types of events. So we really do all types of work. We do litigation type work, as well as research and development for government and private entities as well.
Let me have just a moment, Your Honor.
Yes.
I'm going to have to go back and see what company
Can you give me
the
a
experts in
brief
Paltrow
synopsis
worked
of the
for, because they were great too.
professional discipline
They were based out of
injury
Utah, but this
causation
is a
biomechanics? What is
national.
So injury causation biomechanics is really applying traditional engineering principles to the human body. So as a biomechanical engineer, I look at the response of the body to accelerations and forces and determine how an injury occurs. You know, an injury to the human body is just an engineering problem. For instance, a mechanical engineer might look at a piece of steel and you know the size of the steel and the shape of it. And if you apply a force in a certain direction, that steel will bend and eventually break. Well, we do the same thing, but we look at the human body. How much force do you have to apply, and how does that force have to be applied in what direction or manner to get a specific injury, whether it's a skull fracture, an intervertebral disc injury, a concussion. So we look at the response of the human body to different forces and accelerations in different types of settings. And ultimately, our hope is to help mitigate or prevent injuries, whether it's in a motor vehicle accident, sports setting, industrial setting, auto pedestrian impact, try and make products and environments safer for individuals.
And that's different from what medical doctors do, correct?
It is, yes, sir.
Little boy
thank
walks
you,
into
Smart
the
Fana.
ER with a broken arm. The medical doctor wants to reset the arm and fix the arm, correct?
That's right, yes.
What does a biomechanical engineer want to learn about the broken arm?
We want to learn how that break or that fracture occurs. I always say that we kind of approach injuries from two different directions. You have an injury occur. After it occurs, moving forward, that's when the medical doctors get involved. They diagnose the injury, determine the best way to treat it, what's the prognosis.
How do you fix it?
As a biomechanical engineer, I kind of take the reverse direction.
What the fuck
We
happened?
look at, here's the injury, here's what's diagnosed. Well, how did that injury occur? You know, how much force do you have to apply to cause that fracture? How did the bone have to be loaded? How did it bend to actually cause a specific type of fracture? So we really kind of approach the injury from two different directions.
Understood. And given that...
Favorite thing about experts, when they fucking love what they do. You can tell that both of these experts are geeked by what they do. I love to see it. I love to see people that are like, I do the coolest shit in the world, and this is what I do. I figure out how stuff happens. It's awesome to see. This is incredibly unique in this case because I have never seen a case, and I don't know if anyone else has either, where neither the defense or the prosecution brought in the experts because the strangeness of the ongoing federal investigation, bringing in their own experts to testify to a different grand jury, is so wild that you now have experts who were not retained by either party in this litigation who came in completely. Can you explain what happened? Help us be fact finders. I don't know what can help the jury more than neutral fact finders who looked at the evidence and said, this is what we think happened and why.
Scientific approach.
I am
Oftentimes you can come
geeked.
to conclusions and opinions, scientific conclusions and opinions about the causation of an injury, correct?
Absolutely. Yeah. And I mean, ultimately, that's what biomechanical engineering is how does an injury occur? Why did it occur? And what type of setting did the injury actually occur? What type of loading and what type of kinematics do you need to have this injury actually occur?
Can you tell the court a brief synopsis on the discipline of human factors? What part does that play in what you do for a living?
Well, human factors is a large part of it as well. I mean, from a biomechanical standpoint, we look at the body. We have to know anatomy. We have to know the makeup of the body. And then human factors plays a part of it as well, as how individuals respond or what their response is to different types of environments or reactions. It really all plays into looking at a specific event. How did someone react? How did their body move? How was the body loaded? There's all different types of factors that you have to apply. The human factors, kinematics, kinetics, biomechanical, musculoskeletal interactions. It's all these different factors that are really involved in performing an analysis to ultimately look at injury causation.
Doctor, as the director of biomechanics and human factors at ARCA, what education, training, and background qualifies you to perform those duties?
I like how he works
Well,
backwards.
I got my bachelor.
It's such a smart. I'm going to just keep pointing out for all of you that work or are in law school or what have you, I will always try to point out the good and the bad. There are times Jackson pulls shit in court that I don't think you should pull and a lot of judges would sanction him for. He doesn't care. And he's been a lawyer long enough that he seems comfortable walking that tightrope and I don't give a fuck. But this is a smart way to do a direct examination. Bring everybody in. Are you all interested? Are you sitting there going, oh my God, Sir, tell me more about biomechanics and how much force it takes to break bones and shit. This is fascinating. Before he gets into the background, instead of being like, where did you go to school? And then what? And then what? You know what you're listening to, and it draws you in. It's just a better pattern to get into it, because then the jury, or us as the, the law nerd alternate jury of the internet, is sitting here going, I'm fascinated. Tell me more.
Of science and mechanical engineering with a minor in biomedical engineering from Carnegie Mellon University in 1995. I then went on to get my master's in bioengineering and biomechanics from the University of Pittsburgh in 2002. And then I got my PhD, or my doctorate, in bioengineering and biomechanics from the University of Pittsburgh in 2004.
Can you give us a brief work history up to and before ARCA?
Sure. So I got my my PhD in 2004, and then since then I've worked in the consulting field for biomechanics. I've worked for a company out in Davis, California for a while called Biomechanical Engineering Accident Reconstruction. I then joined another engineer.
Tell me a bunch of engineers named a company when they name the company exactly what they do. They're like, what do we do? Biomechanical engineering. What is the company called? Biomechanical Engineers. Period.
Engineering company in Jacksonville, Florida for about 3 years called Chesapeake Engineering and Design. And I have now been with ARCA for approximately 16 and a half years.
And in those positions and in your position currently as a director at ARCA, do you specialize in research and analysis attendant to evaluating and studying the relationships between crash injuries, crash forces, human kinematics, and human tolerances?
I do. I mean, that's really what I do on a daily basis, whether it be in litigation type cases or the research and development we do for different companies or entities, or even internal research that we perform at ARCA.
Doctor, what professional associations and accreditations do you have?
I'm a member of the American Society for Mechanical Engineers, as well as the Society for Automotive Engineering. Yeah, with respect to biomechanical engineering, there's no actual professional licensure for biomechanical engineering. So a PhD or a doctorate's the highest degree you can have in that field.
Y'all would have the most interesting conferences. I feel like there needs to be an association of the biomechanical engineers. I feel like the plaintiff's lawyer bar would invite you to all of their conferences, which mostly are just people having drinks and going to dinners. But still, that's, what it would be. The plaintiff's bar would be like, come have drinks.
Are you also a reviewer for archives of physical medicine and rehabilitation and biomechanical engineering online?
I am, yes. Usually if you publish articles in a journal, usually that journal comes back to you and asks you to be a reviewer. So I certainly do that type of work as well.
Because you're published.
About your ongoing education, your professional education after your PhD. Have you continued your education in areas of biomechanics and high impact injuries from the NTSB?
I have. I've taken classes through the NTSB and SAE, the IPTM, Police Technology Management Training Center. There's several different entities I've taken biomechanical and accident reconstruction courses through.
So the alphabet soup, if you will, of biomechanical engineering and human factors.
Right, yes.
And you continue that today?
I do, yes, sir.
Any specific training in human kinematics?
Yes, I do have training in human kinematics.
Just out of curiosity, how would you define what is kinematics?
So kinematics is the motion of the human body and looking at how the body moves. And it's irrelevant or irrespective.
And stuff. I'm told that there needs to be an and stuff. But do you see how Jackson set this up? He knew what he wanted to ask these experts. So he asked and made sure he asked the prosecution experts the same question to set up the very stark difference between the answers. It is a very good strategy. And I don't know how much he actually thinks that through anymore or how much it is just second nature, but that's what it is.
Of the forces that cause that motion. So we're really looking at for instance, how one body part moves with respect to the next. We can see how the body moves as a result of a specific type of event.
You mentioned injury mechanics previously in one of your answers. What is injury mechanics, and how does that relate to biomechanics?
So again, that's a subset of biomechanics, looking at the response and the strength of the different parts of tissue of the human body. On a very basic level, to get an injury or have an injury occur, you need really two factors. You need enough force to cause injury to the tissue, and you need that force applied in the right manner. So if I wanted to fracture my elbow, I certainly couldn't take a hit on my shoulder and expect my elbow to fracture. Its force is exerted in the wrong location. And likewise, if I just lean my elbow on the counter here, that's not enough force. So you need the force and you need the application of that force in the correct manner to produce what we call an injury mechanism.
So what, if anything, do you know about pirouettes?
Have you participated in any studies or research in this area? In addition to your dissertation, getting your PhD,
I'm going to bet that's
what about
a
additional studies and
yes.
research in this general area?
I have, yes, sir.
Can you describe that for us briefly?
Certainly. Well, just at ARCA, I've worked with the United States military. We worked on the design of the MRAP vehicles, the mine-resistant ambush-protected vehicles over in Iraq and Afghanistan.
That's a troop carrier, correct?
That's correct, yes. And the issue there is they go over the IED, the improvised.
Did you hear Jackson couldn't help himself? He's like, that's a troop carrier. Tell me more. Former Air Force.
Explosive device, and it blows the vehicle up off the ground. So you're getting very large forces and accelerations through the vehicle, through the seat, into the soldier's spines. So we're seeing very traumatic and severe spinal and head injuries.
I would imagine
so. At ARCA, we work on what we call an energy absorbing seat design. So when the vehicle gets blown off the ground, that seat is designed to absorb the force and the energy to protect the soldier's spine and their head.
That's fascinating.
Did you take part in the design of that seat?
I did, yes, sir.
Has that been employed by the Department of Defense?
Yes, it has been.
And are troops utilizing that new seat design, that safety seat design?
The jury is going to love this man.
As far as I know, is from what they'll tell us, yes, sir.
Are you also published in this field?
From what's not above my security clearance level, this is what we know. The jury is going to love this witness. They are going to love this witness.
I am, yes.
Can you give us a couple of examples of current studies that you're involved in or publications that you've done in the recent past concerning bioengineering and the impact or the association that it has with human factors?
Sure. I mean, and another project I'm working on is we work with the NHL actually at ARCA. We have an ongoing.
That's easier.
Well, we have an ongoing relationship with the Department of Player Safety. For instance, we helped redesign part of the rink. In every arena, they had at the end of the player area, there was basically a 90-degree stanchion where the glass met. And so players were kind of getting checked down in the boards and then hitting up against the glass. And actually, somewhat ironically, it was Chara hitting Pacioretty into the glass, the Boston-Montreal game, and caused a cervical fracture and concussion.
Ouch.
And the NHL came to us to see if we could have a redesign of the rink to make it a little safer. So we took crash test dummies, the anthropomorphic test device, which you've probably seen on TV.
Wait. You didn't just take like a boxing fighting dummy and stick it out there. You had actual ones and then redesigned all the rinks for the NHL. Please tell me more.
The automotive manufacturers use them all the time and threw them into different configurations of glass. And now in every arena in the NHL, it is basically a curved piece of spring-loaded Lexan or plexiglass where the players they hit into it, it absorbs the impact, and they glance off of the glass.
Is that a design that you helped come up with?
It is, yes.
So both from the
United
United States military as well as professional sporting leagues, they've come to you.
Okay, not only is that super cool, but he's kind of just like, I mean, yeah, I redesign stuff so people don't get hurt, but also how cool is your job to be like, let's throw a bunch of crash test dummies at hockey rinks and see how we can make this safer. That's very cool. It's just a cool job.
You to help save lives, lower risk.
That's right, mitigate and prevent injuries, yes, sir.
You get to be like a myth buster plus a doctor.
What about crash and sled testing?
Yeah, I've performed a number of crash and sled tests. When you look at any vehicle that's driven in the United States, it has to pass federal motor vehicle safety standards. There's federal regulations that they have to pass, and part of that involves running the vehicle into a wall at 35 miles an hour, hitting it from behind, rollover type impacts. And they have these crash test dummies in those vehicles. So we perform a lot of testing for different cases and situations where we put that dummy in the vehicle and we evaluate the safety system, whether it's the lap and shoulder belt or if it's the airbag or the seatbelt pretensioner, determine how to make the car safer. And part of that is looking at the force that's exerted on that dummy, because there's tolerance values. We know
how to make cars safer. Can you just teach people how to drive better? Because that would sure help. It would sure help sometimes.
how much force it takes to cause specific injuries. So we
Or
want to
less
make sure in
distracted. I guess
certain
less
instances
distracted
at
would
certain
help too.
speeds or impacts that if someone's in an accident, the force acting on, say, their head or their neck or their chest is going to be below these established tolerance values.
Sir, can
Speaking
you,
of
sir,
how much force-
can you talk about everyone in this case drinking and driving? Can we talk? Can we just have a, sir? Maybe you're the one to have a brief conversation about why that's such a bad idea for everyone involved in this case. I know, chat. You're like, he's not a miracle worker.
Force it takes to cause an injury to a human body. Have you engaged in any testing or published in the field of auto pedestrian incidents?
Yes, I've been involved in a number of studies where we're looking at auto pedestrian type impacts. Again, a lot of times we'll utilize the crash test dummy where we'll set it up and we'll actually have it struck by different vehicles or different objects to look at the response of the body. It's very important if you're talking about an auto ped type impact. You have to know the configuration of the pedestrian, the vehicle, where they hit on the vehicle, whether it's...
Wait a second. So the chat, sorry, there's a lot of y'all in the chat, which is amazing, but somebody just said that ARCA has a YouTube channel. Well, that's fascinating. I wonder if they talk about the different studies that they have done. Thank you, chat, for pointing that out. In a positive way, we enjoy the like, hey, if there are people that we don't enjoy, we are just going to keep moving along. When there are people we stand, we find a way to support them. It is a healthy way to internet. Lift people up, and it naturally lifts people up. There's no need to tear people down. You just lift the people up that do good things. So I appreciate it, chat. Thank you.
It's a projection type impact, a wrap, a fender vault. It really all depends on how the person's positioned and the amount of force and speed involved in that type of an impact.
And staying with that for a second, that basic subject matter, have you also engaged in studies related to slips and falls where somebody might fall from a standing position and injure themselves either to their head, shoulders, whatever?
Interesting.
And those kinds of injury impacts.
Interesting.
I have, yes. And then one of the issues we look at it there is a lot of people fall, especially elderly people. So we want to look at what types of forces are being produced.
Chat,
you
do
look
you
at
see
hip
what that's going
fractures.
to?
If you slip and fall backwards, head fractures.
Right.
So we're trying to determine
What happens? Sorry for the
how to
pause.
prevent those falls.
What happens if someone slips and falls backwards? Can you see the line of questioning that is going to happen based on just what we know? And can you imagine when the state finally rests their case, what a stark contrast these witnesses are going to be to some of the witnesses we have seen? It's staggering, the difference to me. Let me know if it's as staggering to you. Is this a stark difference?
Falls from happening, and also create devices or products that can help actually prevent injuries if someone does take a fall.
Doctor, have you been retained as an expert in the area of biomechanical engineering and human factors in the past?
I have, yes, sir.
May I approach, Your Honor?
Yes.
Can you take a look at that document and tell me if you recognize it?
This is a list of my deposition and trial testimony.
Your Honor,
Well, it's
I
not a
provided
trial.
that to the court this
Yes,
Deposition
I
testimony.
appreciate it. I had a chance to look at it.
The deposition testimony is from that federal grand jury.
That's about a 14-page document, is that correct?
That's correct, yes, sir.
Quick
Let me just ask
testimony.
it this way. How many times do you think you've been qualified as an expert in the field or testified as an expert in the field of biomechanics?
For everyone that said big, huge. I
I've
see- I
testified
see
probably over 150 times
Movie
in
reference.
numerous state, federal, civil, and criminal courts
course you
throughout the
have.
country.
Your Honor,
150
I'm sorry,
times
may I approach?
Yes.
is a ton of testimony.
For the purposes of voir dire, Your Honor, I would ask that this document be marked.
Sure.
Thank you. Have you ever testified in criminal court as an expert in biomechanical engineering?
I have, yes.
How recently have you testified in criminal court?
Well, actually,
Yesterday.
just recently I've testified twice. The end of May, I think May 31st, I testified in McKean County, Pennsylvania, For the prosecution, it was a case where the defendant was accused of beating his girlfriend to death and basically said that she fell down the steps. So my testimony involved determining how her injuries occurred
and that
they were entirely inconsistent with what would have happened during a stair fall.
What about another case?
Why does this matter for the defense? When the defense is offering experts that will testify on both sides, they've testified for defense, they've testified for prosecution, they've testified for plaintiffs, they've testified for defendants. It gives a neutrality to when somebody asks us how a thing happens, we come in and tell you how a thing happens. Is this consistent with that? It's not just a, oh, well, we're a defense expert for accident, whatever. It's we are experts, period. And if people need us, they come to us because we are the best. There is a neutrality to that of we just look at what happened, just the facts. And can we make a determination? It is a very, very lucky thing for the defense, again, that these experts were basically delivered into this case by the federal investigation. Here are the reports that we used in our grand jury. Plunk. And this is who they chose. And of course, this is who they chose. But ask yourself, if this is who federal prosecutors chose, why did we wait to get to the defense to call these experts?
And then about a week after that, around June 6th or 7th, I testified in Cambria County, Pennsylvania, again for the prosecution for another homicide case where the defendant was accused of essentially beating his wife to death and then said that she actually fell backwards and struck her head, caused a skull fracture on the side of the sink. So my testimony, again, pertained to looking at the injury mechanisms and determining that his story of her falling back and striking her head on the sink, it's inconsistent with the injuries and the type of force that would have been exerted in that case.
So
In both of those murder cases, you were hired
DV-related
by
homicides.
The prosecution in the case, not by the defense, correct?
That's correct, yes, sir.
You gave your opinions in furtherance of the prosecution's case in chief, not the defense case in chief.
That's correct, yes.
Jackson is going to make much of that when he testifies in front of the jury, I'm sure, as he should.
With regard to this case, you were asked to look at several items. We've already gone over those in the other testimony, so I won't belabor that. You were asked to look at several items, correct?
I was, yes.
And ultimately, based on that that series of information, that universe of information that you were provided, see if you could come to an opinion and conclusion concerning the incident before the court now, correct?
That's right. See if I could determine what happened, how the injuries occurred, and the events leading up to and during that process.
Without going into your conclusions and opinions, were you able to come to conclusions and opinions to a reasonable degree of scientific certainty?
I was, yes, sir.
You were not hired by the defense, by me, or anybody on the defense side in this case, correct?
That's correct. I was not.
You were not consulted with or hired by the Commonwealth either?
That's correct. I was not.
It was a completely independent agency, is that right?
That is correct, yes, sir.
Before this morning, have you and I ever met?
No, sir.
And you and I have never talked about the substance of your opinion and conclusion, correct?
We have not. That's correct.
You did reduce those opinions and conclusions in conjunction with your team to a report, is that right?
I did, yes, sir.
And your understanding is that report was made available both to the defense and the
And it was.
Is that right?
Yes, sir. That's correct.
I have nothing further to
Okay, Mr. Lally?
Thank you, Your Honor.
Mr. Lally? I don't know what you're going to ask, sir. I'm fascinated. Sir, are you going to ask, did they give you all the information? Just
good guess.
Just a few questions for you, sir. Good afternoon.
Good afternoon, sir.
Now, with relation to your work in this instance, in this case, were there any limitations as far as confidentiality or anything that were put on you or any of your team?
What do you mean by confidentiality?
As far as who, what, where, and
security
how you could
clearance.
discuss, what you did.
Well, yeah, I mean, certainly we just discussed with who we were retained by in this case. I don't believe I discussed the case with anybody else except for my cohorts who were also involved in the case.
You didn't send a whole bunch of text messages to your high school buddies and be like, you're never going to believe this grand jury that's going on? Sir, what? I thought that was standard. I'm Emily, too sarcastic. It's early.
And so my question, sir, more is geared towards, at some point you were made aware that your report and your findings were made available to both the prosecution and the defense in this case, correct?
I was made aware of that, yes, sir.
And when you were made aware of that, was there any limitations on given to you as far as who you could discuss your report, your findings, or anything with?
Yeah, basically given the direction or the request that I don't actually discuss the substance of my opinions or my report with anybody aside from who we were originally retained to work for.
Now, may I approach, Your Honor?
Yes.
Sir, I am going to show you the first couple pages of your report, specifically right down the bottom. There's a list of items 1 through 14. I asked you to review those.
Those are the items he would have reviewed, I would imagine. Leonards, welcome to Voir Dire Day.
The totality of information that you and your firm
Just
were
going to take a minute
provided
to remind you to get the Leonard app if you couldn't get it yesterday.
I believe it was, yes, sir.
We broke it.
So nothing
It's back.
beyond that list of 14 things did you have occasion to look at, review, or have any opportunity to see at any time?
Well, aside from we did do testing in this case, so we did do other
Aside
work.
from your independent testing, I'm asking as far as material provided by whoever employed you, that is.
Lally, this witness is eminently likable. More likable than a lot of engineer witnesses. He is personable. He speaks at a level that is understandable without being condescending. This is a very likable witness. If you have not already pissed off this jury with what, if anything, sort of where did you sit in the bleachers at the fucking Canton basketball game, going after this witness is danger, because you are going to piss off the jurors who just are there to find the facts. And I imagine that what they would like more than anything, because that's what I see from 40,000 people day in and day out, is they would like to understand what the fuck happened to John O'Keefe. Not what Jen McCabe did on her phone, but what happened to John O'Keefe and investigation did to solve it. Everybody just wants some answers. And if you start snipping at the witness who is there to provide some clear testimony, it is going to turn out badly for you. This is not the one. This is not the one for an aggressive cross. This is the one for a minimally aggressive cross, because he is likable, qualified, and neutral.
The sum and total of what you received, correct?
I believe that would be correct, yes, sir.
And did you personally review each of those 14 items? Because, and I don't fault you or your company for this, but within the report, there's a lot of weak. So what I'm asking is, did you personally review each of those 14 items that are listed in that report?
I did personally review every bit and every page of information that was provided in this case. Yes,
Yep.
sir.
And to be clear, just to sort of close the loop on this, when it comes to those 14 items, were you allowed to ask for any additional items, or was it just you were limited to, this is what you have, go form an opinion?
There may
What
have been
more is
discussion
there?
about if there's other information available, but I believe ultimately that we rendered our opinions obviously just on this specific information that was provided to us.
Now, as far as your opinion in your report, when was that issued?
February 12th of 2024.
So that date on the top of the report of February 12th, 2024, that's when you sent the report to the people that contracted you to do
The
analysis
DOJ.
in the first place.
That's correct, yes, sir.
May I approach you?
Yes.
Thank you.
Sure.
The timing's interesting. And we know more about that grand jury because we've heard from so many witnesses who testified in it. That was a long grand jury. It was not quick. And it was ongoing, well beyond February.
Now, am I correct? And what I'm trying to ascertain here, Doctor, is just sort of
trying to bite in my snark.
different roles that you and the other members of your team performed in reference to this. Am I correct in that your primary role in this
pertain to the sort of biomechanical
Physical
engineering
injuries.
analysis of injuries sustained by Mr. O'Keefe?
That would be correct, yes, sir.
And not to put too fine a point on it, but Dr. Wolfe would have been more responsible for issues related to the vehicle itself.
Generally speaking, yes, that would be correct.
Obviously, there's some interaction between damage to the vehicle and injuries to Mr. O'Keefe, but as far as your primary sort of any opinions contained within this report pertaining to injuries to Mr. O'Keefe, those would be your opinions, correct?
Yes, any opinions or information with respect to the injuries would be my purview and my opinions in this matter. Yes, sir.
Biomechanical.
Concomitantly, so any opinions related to damage to the motor vehicle, those would be opinions of Dr. Wolfe, is that right?
Well, to some extent. I mean, certainly I would have opinions as well based on the interaction or alleged interaction between the body and, for instance, the vehicle in this case.
I caught that, sir.
What damage to both the body as well as the vehicle you would expect. So I think there's basically some overlap between those issues. I wouldn't say that it's a complete separation.
The alleged interaction.
And so, and again, Doctor, what your opinions or ultimate conclusions are, whether they be yours or Dr. Wolfe's or a combination of the two.
Runkle, good to see you in the
It's
chat.
all limited based on
Yeah,
the
these are great
information
witnesses.
and
The jury's going to
evidence
love
that
them.
you received, correct?
It certainly is based on the information that we reviewed and listed in our report. Yes, sir.
Now, as far as sort of
The jury's going to
mandate
really
or
like these witnesses.
from the agency that hired you, were you asked to answer a specific question, or were you asked to just
The agency
do an
that hired
analysis
you?
based on what we sent you, or how was that?
I promise I'll stop
put to
eventually.
you as far as what you were doing?
There was a specific request that we were asked to perform and to evaluate in this case.
And specifically, what I'm asking, sir, is there's an analysis in there of whether or not the injuries to the back of Mr. O'Keefe's head could have been caused from contact with the vehicle, correct?
That is part of my analysis and opinions, yes, sir.
And were you specifically asked to address or answer that question by the agency that hired you?
That was one of the questions I was specifically asked, yes, sir.
I have nothing further.
Anything further, Mr. Jackson?
Thank you.
All right, so Doctor, I have a couple of questions for you, sir. So regarding this specific request, what were you tasked to do specifically?
So specifically overall, I was tasked from the biomechanical standpoint to determine or see if it's possible to determine how the injuries in this case occurred. And part of that was determine whether the injuries, the head injury and the arm injuries resulted from contact with the Lexus in this case.
Okay. And regarding all of your prior testimony, a good deal of it seems to be in depositions. Any of those in Massachusetts?
There's a couple, I believe. I've testified at trial in Massachusetts,
Okay.
Middlesex Superior Court.
Do you know where that might be? I do want to
He
look at
just
that.
said-
I can find it for you, maybe a couple of months ago.
Was it in a criminal case or a civil case?
Oh, it was in civil case. I
Okay.
think, let's see here. I think, yeah. So let's see. There was one November 14th, 15th, 2023, Middlesex Superior Court. That was probably the most recent one.
Hey, what
In
number is that on there if I want to
And
go
that
back and
will-
look at it?
That is number 310.
Thank you. Is there another Massachusetts case?
Oh, I'm sure there are because I know there's some from earlier in my career.
Biomechanics don't work different in the state of Massachusetts. The DOJ chose to pull these witnesses in, Your Honor. Okay.
Let me see.
Okay.
See if I can find them for you real quickly here.
Hold on, Your Honor. I've testified so much that it's going to take me a minute to go back and find all of it.
Yes.
Why is she asking those questions? I don't know. She wants to.
Connecticut.
She didn't ask the last witness. So why is she asking this of this witness? I don't know.
Louisiana.
What, if any, states have you not testified in, sir? How about we go from there?
Oh, there's 68. I'm gonna butcher it. Worcester.
Worcester. Is that a civil or
Worcester.
criminal case, Doctor?
That is a civil case as well.
Okay. What year was that?
Oh, that one was 2012.
He
Okay.
just testified in two
Any others that
criminal
you
prosecutions
think of or you see?
within the last
There
4
may have been a
weeks.
couple others. I don't recall off the top.
All right, I'll go through it more closely. I
Sure.
appreciate you saving me some time.
Absolutely.
All right, any questions based on my questions?
No, thank you, Your Honor.
Why does it matter?
No.
All right, you are all set, sir. Thank you very much.
Thank you, Your Honor.
I think that's going to be the end of our voir dire day. Yes, the gravitational pull of Pennsylvania and Massachusetts apparently are different, chat. All right, let's see what the court has to say. And then we'll answer a bunch of questions because we're going to be just about done for the day. Because we are just
All
about done
right,
for the day.
so Mr. Lally, I will hear you on your.
Just a reminder, we are here on the prosecution's motion to exclude. The first witness that testified during the voir dire was the witness that was most on the bubble about whether she would be allowed in or not. The court has already ruled that there was a Rule 14 discovery violation. It's trying to determine what the sanction is for that. I think ultimately the sanction for that is going to be the voir dire that we just saw. These two witnesses, the Commonwealth moved to exclude, saying the defense hasn't turned over, and we saw this argument last Monday, the defense hasn't turned over any more information. And the defense said, well, the court said we can't talk to them. So we've got their report and we've got their prior testimony, and that's all we've got. And the court said, bring them in for voir dire. Jackson and Yannetti were ready to just roll on those witnesses, just like put them on the stand and let them go, because Jackson and Yannetti and the Commonwealth got all that information from the feds at the same time. So Jackson and Yannetti, I don't think, failed to disclose anything under Rule 14 because they were told not to talk to them and everyone had the same information. So the court wanted those two witnesses brought in for voir dire to determine if they would be allowed to testify. We're going to hear the argument on that now. But again, I don't think the court will exclude them. They are incredibly neutral. They came into this case without either party bringing them into this case, but because it was disclosed by the feds that they had these accident reconstructionists. So there's not much the judge can do to exclude them, really. It's not late discovery. The remedy is to let these questions be asked. It's been done. So let's see what happens.
Motion. Now, we didn't get into the ultimate opinions and the basis for that
I don't
opinion.
think you needed to.
But I'll hear you on your motion.
Your Honor, what essentially what Commonwealth was seeking and had been seeking was just in reference to that, as far as who did what and who was responsible for what and what were the items reviewed, and is that the totality of it?
Well, that's Lally has said this was the only confusion. The reports said we. So I don't think there's any issue here at all. The reports said we. I needed to understand what each expert did. Now we understand it. So I don't think there's an issue, which is fairly stand up of Lally to just say, that was my issue. It's been answered.
There's a date on the report. I don't know if that was the date as far as when it was filed, when it was opinion was rendered, when that was provided, what was provided to them in the course of their analysis. So I think
his questions are answered.
Very simply, what the Commonwealth had been seeking for the most part was covered today.
Okay.
Right. There we go.
All right.
Problem
I have some
solved.
questions as to the scope of the testimony of the witnesses.
If the Commonwealth doesn't have an issue, don't make an issue. It's like when all of the attorneys agreed that they were going to pre-mark the exhibits and you said yes and then changed your mind. Like, just your job, Your Honor, is to referee. Just balls and strikes. The Commonwealth is like, we're satisfied. Questions have been answered. Good. Done. What else? What else are we doing? Why?
So, Mr. Jackson, you intend to have them testify consistently with the report, everything covered in the report?
I mean,
And the conclusions, all 4 conclusions in the report?
he intends to ask them the questions. If they testify consistently, is on them.
Report?
Correct.
All right, Mr. Lally, what's your take on this?
Fine. I don't know if Lally heard her.
I do have an issue with number 4. I don't think they're qualified to testify to. I don't think either of them is qualified to testify to that.
We don't know what that is.
More of an area
we
of
can't
forensic
see it.
pathology.
What do you say to that, Mr. Jackson?
He should be allowed to
Number 4 is,
develop it when they come in.
There is currently insufficient evidence to determine the cause of Mr. O'Keefe's skull or brain injuries or the circumstances surrounding.
We didn't know what number 4 was, and Alan Jackson has now read that into the record for us, so I'm going to back it up. Each of these the experts rendered 4 conclusions, and it seemed that it was a joint report, and they were trying to parse out who did what so they know what to ask each person when they testify. So the court is like, well, all 4 of the opinions, yes. Lally's like, actually, I have a problem with number 4. So Jackson's now going to read 4 into the record because we don't have these reports and we don't know what they are. So let's hear what Jackson has to say. So
Number 4 is, their opinion is, there is currently insufficient evidence to determine the cause of Mr. O'Keefe's skull or brain injuries or the circumstances surrounding the event. That is well within the scope of their expertise. Obviously, I don't think I have to beat this dead horse. They are highly, highly qualified to review all 4 opinions. And if the evidence in their opinion, their expert opinion, to a reasonable degree of scientific certainty, which is what's evidenced here by the report, is that there is insufficient evidence to determine the cause of Mr. O'Keefe's injuries, then that is an opinion that they are well within their it's well within the scope of what they can testify to.
I don't know if both experts are qualified to testify to that, but I don't think he's going to ask both experts. I think that is the opinion of the second expert, the biomechanical expert, who is clearly an expert. The first expert is probably not offering that opinion as to the undetermined cause of the victim's head injury, which seems to be consistent with the undetermined cause of death by the coroner. But I think that opinion goes to the second witness. And I wonder if with 1, 2, 3, 4, it is the first 2 go to the first witness and the second go to the second witness. But Lally saying, I'm spitting. Lally saying neither of them are qualified after Trooper Paul testified is just
That's their opinion. That's their conclusion.
Yeah.
Mr. Lally is going to have an expert, Trooper Paul, who is going to differ, or who has differed in that opinion.
Who has differed.
And I would have kept it out. Remember, I would have kept out any medical part had there been an objection. And when you objected, I sustained the objection.
No, I think we're talking about 2 different things, apples and oranges. That's not, Trooper Paul's opinion is that his injury or his
is consistent.
Or I think he said variously that it was blunt force, could have come from the curb.
It was consistent.
Or it was blunt force because the road is blunt. That was his opinion, and he was sticking to it. This is contrary to that. Both of these individuals have come to the conclusion and opinion that the evidence is insufficient to support that.
Right. So the defense made a tactical decision.
In their purview to
probably a good one.
If I may, I don't think that's their actual opinion. I initially didn't think of it in these terms as it's phrased on the cover page of the report. If you look at the actual opinion,
I was looking at the last page. Are they the same on the front and the back?
I think the front is a little more definitive and concerning. The back, I think, more as to it's consistent with a whole multitude of different things. So the fact that I don't really think that's an opinion at all, to be honest with you.
All right, I'll take a look at this more closely, give you a decision Thursday. All right, I did not expect it to go this quickly. We could have had the jury here, but
yeah, I'm
sure you all could use the afternoon to prepare.
They probably
all right,
can.
Mr. Lally, let me know Thursday if
they
you
could have
need,
brought the jury in after lunch.
Are you ready to go forward at least with your case on Thursday?
Oh, yeah, sure.
Let me know Thursday if you need additional time. If I let Dr. Russell testify, how that impacts our schedule.
Absolutely, Your Honor.
All right, but I don't want that to be a concern of yours, how it impacts the schedule. That's my concern. I just need to know. All right, so anything else?
That's it for the day.
I think that's it. Thank you.
Okay, we'll see you Thursday morning.
Yay! Half day. Let's answer some questions, shall we? Well, that was fascinating. God, I love a voir dire day. That was cool. Chat, do you agree? Did you have a good day? All right, chat. We're just at lunch. We're at our normal lunchtime, and we were probably about 20 minutes behind real time. So look at us go. Everyone can go catch up on Bridgerton or start downloading the audible books of, the ACOTAR series, whatever you decide to do with the day. But I'm going to answer some questions. So if you've got questions, I've got questions. Let's do a summary of the day and then do questions. And then we're all just, that's enough work for this day. Can you tell how excited I am? Emily, do you need a day? Yeah, I have to decide what I'm going to pack for VidCon. And I got to get ready for Dave. And I might have time to go get my eyebrows done. Look, the amount of work that goes into getting ready for an event for me versus, I would imagine others is so different. Like, do we refresh the purple? Do we not? There's lots of planning, executive functioning needs to happen. And I still have energy, so I can do that today. Let's do a quick summary. Emily, you're rambling. Yep. Let's do a quick summary. All right. Law nerds, we are at the end of voir dire day. All three witnesses went pretty quick. The judge seemed shocked, which is funny to me because when the attorneys told her, each of them said it would take about 20 to 30 minutes per witness. So less than an hour per witness. And that's what happened today. And then the judge is like, that went faster than I thought. Yeah, it did. She also said, I think you all can probably use the afternoon, and they probably can. They've had quite a lot of breaks, but Tuesday was normally a half day in this trial, so it gives that half day. Let's talk about what happened. The first witness that came in for voir dire because the prosecution made a motion to exclude witness testimony, and the solution that the judge came to was bringing everybody in for voir dire, and that's what they did today. The first witness is a doctor who has done studies in police dog bites, who identified the injuries to the victim's arm as dog bite and scratch, or consistent with dog bite and scratch injuries. And that's really the heart of that expert's opinion. I think the judge is going to let it in. I think the judge is going to narrow down that testimony to the opinion that the injuries to the victim's arm are consistent with dog bite and scratch, but not that it's inconsistent with an automobile collision. But the other two experts that we saw are going to testify to that. And the witness talking about the injuries to the victim's arm also said that she considered things like the lack of other injury. And not only had that doctor worked as a forensic pathologist coroner, but also worked in one of Los Angeles's busiest emergency rooms and level 1 trauma centers at County USC. So that witness has seen all different types of injuries, and also just because life worked as a police officer and was also trained in accidents. So a tremendously qualified and very uniquely qualified expert who came to the attention of Alan Jackson because she is working a cold case with a cold case district attorney in Los Angeles, where Alan Jackson also used to work and actually ran for district attorney. But that district attorney who knows Alan Jackson because they worked in major crimes together reached out to Alan via text and said, hey, I've got this witness on another case who's heard about your case. You might want to talk. And then Alan contacted her. They talked, and now she's coming in. I think the judge will allow that witness to testify. I will be very surprised if she does not, because there's no reason to exclude it. And the judge, I think, is signaling to the prosecution she's going to allow this in by saying, Mr. Lally, let me know if you will need extra time if this witness testifies, because those are the things to remedy any late turnover from the defense, is to give Mr. Lally more time. Does that mean this jury might end up deliberating over 4th of July? Probably. Yeah, probably. Does that mean we won't be on jury watch while I'm at VidCon? Yeah, maybe. So that'll be interesting. So the next two witnesses wrote, it seems, their report together. So a lot of what was in that report said we. Both of those witnesses work for a private accident reconstruction firm and have different specialties and seem eminently and immensely well qualified. One of them has testified in over 150 different matters. The other one has testified in over 20 different trials. They helped redesign the NHL hockey rinks to cause less injury. They are biomechanical experts, and they were brought in as part of the federal investigation. So they were hired by the Department of Justice to testify at the grand jury that is looking into this case. It is incredibly unique that there is an ongoing federal thing while there is an ongoing state trial. Often the feds don't start their investigation till after there is a trial, and then they start looking into those violations, or before a trial is ever underway and they intercede. This is very odd to have the overlap of that federal investigation and grand jury while this trial is ongoing. Both parties in this case asked the judge to continue this case when they were made aware of that federal investigation and grand jury and witnesses who testified. And the judge said no. So what is the result of that federal investigation? We don't know yet. After this trial concludes, I will go back and look more into what is known. There were several court hearings about it, but I wanted to go into this case like a juror and try to keep my outside information limited. So we will dive into that again, because I'm sure we will hear more from it after this case concludes. No matter what the jury finds after this case concludes, there will be more to hear about that. So those witnesses both testified. I don't think the court is going to limit their testimony. I don't think the court is going to be able to keep out their conclusions. Neither side hired them. There's no discovery violation. That information was turned over by the DOJ, and the Commonwealth said, my questions were answered by these witnesses. The report kept saying we, so I didn't know who did what. Not to tangent on the fact that half of that might be hyperbole, but a large number of the prosecution's witnesses said we throughout their entire testimony, and nobody had a fit about it. But whatever, the prosecution said, I need to know which expert did what, and now they know. It wasn't until the judge started prodding a little more that the prosecution was like, oh yeah, and I don't like conclusion number 4. Conclusion number 4 is that the victim, John O'Keefe's injuries cannot be determined. The head injury cannot be determined to come from a motor vehicle collision. So we're going to see what happens with that. The judge is going to rule Thursday. Remember, no court on Wednesday. And one last time to remind you that the Lawnerd app is ready for you. The volume of Lawnards in this app is absolutely incredible, but I will keep you in the loop when I go live, when we are doing things, and importantly, when the witnesses you want to see testify and when there is a verdict. So the Lawnerd app is our way of keeping you in the loop. It is the best international solution we have come up with. So we built it so that you don't miss what matters to you. And when life gets busy, you know you can pop out and we'll let you know when cross-examination starts. I know how important that is in this trial. I see you guys coming into the comments and saying, Emily, I'm sorry, I'm just coming back for cross. Don't apologize for me. I'm not the DA asking what, if any, sort of stuff have you done. I'm not offended at all. I know a lot of you hang out in the chat just to talk to each other while getting other stuff done during Lally's difficult questioning. I get it. We're neurospicy. Sometimes what, if any, makes you want to actually pull your own brain out. I understand. It makes me want to scratch the inside of my head too. So the Lawnerd app is there for you. All right, let's get to your questions. And then we're going to take the day. We're going to take a half day. So let's get to your questions. Lawnerd chat, it is so good to see you. Emily, where is your soundbite, the FBI, from? It's driving me nuts that I don't know. Amy, there is a whole backstory and lore to that soundbite. It is from a movie. That is not where I found it from. I love radio. I think that if I had been honest with myself growing up, I probably always wanted to be a broadcaster. And now we're here. So am I shocked by that? No. But I grew up on Kevin and Bean on K-Rock, the world famous 106.7 in Los Angeles. That is a soundbite that they used forever that came from that darn cat. So that is where that soundbite came from. But in the lore of my life, every time I hear the FBI, because I listened to the Kevin and Bean show so much, it is like ingrained in my soul that when somebody says the FBI, what I hear is literally the FBI. When one of the DAs I worked with was interviewing with the FBI and ultimately left the office to go work at the FBI, the entire time he was talking about the interview process for that, I would sit there and just yell the FBI every single time he said it, which I'm sure was imminently annoying. So sorry. But also, you ate your yogurt loud, so I feel like it's a balance at this point because the FBI. Look, when you work with people that closely, you know things. So I couldn't stop with that soundbite because that is what plays in my head anytime anyone ever says the FBI. So Amy, thank you. I see you in the chat saying I remembered it's from Kevin and Bean. Yes. So that is the entire thing. So but I miss radio. CeeLo said you ate your yogurt loud. It's true. That's a story for a members only live stream. So that's a thing for another day. Jody's side eye said, question, can't the defense point out that if the Commonwealth hadn't taken so darn long to present their case, Russell wouldn't even be here? I mean, I don't know if it would be helpful, but perhaps. I don't know if it would be helpful. I don't think this case is going to wrap up in the time the court said. Radio Chick 81 said, former radio broadcaster here. It's not what it used to be anymore. I'm sure that it's not. I have friends that work in radio and the way that radio has shifted. But you know, this is just kind of the same, isn't it? I feel like sometimes I'm just like, tonight on Coast to Coast. I feel like we're just there. It's free. I have a regular show. You know what time to turn it on. I feel like we're doing that now. But yes, radio was such a huge part of how I grew up. YouTube is kind of a huge part of how my kids grew up. So we're just here. It's all broadcasting at some point, isn't it? But yes, it has changed quite a lot. And now I listen to the podcasts of the people that used to be on radio. So wasn't K-Rock out of Huntington Beach? It was out of Los Angeles. I mean, they broadcast from a dinky little building in Culver City for quite a long time. Emily, be honest, the loud yogurt eating is the reason why you left the DA's office. No. But that's hilarious. That story for members only live stream, but no, it was truly the health issues because it is a difficult job. It is a great job. I had great colleagues. I worked with amazing attorneys. When I ponder if I'm being overcritical of the attorneys we're watching, it's because I worked with such incredible attorneys. The level of skill of the trial attorneys within that office, I think, is unparalleled. And the more I watch trials across the country, the more fervent that belief comes. And I try to check and make sure I am not biased in that because that's where I worked. But as I watch other attorneys, I just think that they don't have the volume of practice that you get in LA because you have so many cases that the volume of trials you do, look, 10,000 hours of practice, right? The more trials you do, the better one would get at doing trials. And when you're doing high volume trials, you are going to get better at doing trials. And then when your colleagues are amazing, it is going to step up your game. And then when the defense attorneys step up their game, because the DAs are amazing, everyone steps up their game. So Bubble B, this is a comment I get in the chat all the time. I just need to disabuse everyone of this thought. First of all, I would be a terrible judge. I would not be a good judge. I do not have a face to be a judge. I do not have a neutral face. My face says, what the fuck, even when I don't mean to. Like, my face is subtitled. I can't with that. Also, running for judge is incredibly political, and I don't think I have the patience for that at all. Also, it's all executive functioning tasks all day long, like all day. All you do is decide other people's arguments, and then you have to sit and go through all of the paperwork. The checkboxes alone on the sheets would terrify me. The amount of executive functioning. I do not think I would be a good judge at all. I love doing this. I love doing this, but I do not think I would be a great judge. I know a lot about the law, but I do not think I could keep my face neutral, because even when I was sitting at a conference with my team, I was dying inside as defense attorney Bowles was talking about the Hannah Gutierrez and the Baldwin case and wanted to just start yelling. I'm like, I am very much made to be a commentator. I am definitely not made for a paperwork intensive workday that is like, to be honest, a like 7:30 a.m. to like 5:30 p.m. day in and day out kind of job. Nope, terrible. Much better for this. Miss Baker, your face is a household meme. Yeah, I have been admonished for my face. So my face is sometimes loud. My voice is also quite loud, but I appreciate you saying that you think it is something that means that I am qualified in the law. I appreciate it. The judging work is not good. Also, it is deeply politically connected. And I just can't. Shazam said, Shazam, thank you for the gifted memberships. Tower Girl asked, why do you not take cases in court anymore? I don't have time with this, honestly. And then we start running into the realm of conflicts and what I can and can't cover. So I do consulting work, but I don't take cases in court anymore. A, I don't want to fly back and forth to LA to do it. B, I like doing this better. C, consulting is a lot of fun. And then I don't have to do the in-court things because, again, I don't want to be in court every day anymore. I like doing this. And in the summer, I can like take my kids to camp and I'm not missing school events because I have court. It is a choice. I love this. So could I still do that? Sure. Do I want to still do that for my life? No, I don't. Beach Please said, thank you for your gavel to gavel. I love it. You're welcome. This is my being in court day to day, and I get to wear a baseball hat. KJ Pike said, can't wait to see what, if any, somehow, sort of, I'm going to add stuff, happens today. Today was good. Finally able to watch a live. Lisa's so glad for it. Rebecca said, why so many witnesses for the state? Fuck if I know. I think Lally has forgotten he doesn't have to call everyone on his witness list. Emily, what is the most witnesses you've seen for the state's case? Oh God, in these high profile cases, it can be quite a lot. Like if we're looking at like the Young Thug case, I mean, they're going to be into the hundreds of state's witnesses if there isn't a mistrial declared. But in cases I've worked on, in cases my colleagues have worked on, I mean, most people can do a non-complex homicide case in under 10 witnesses. This is a lot. A lot of people can do gang cases, gang homicides in less witnesses than this. It depends on the strength of your case, right? So I've done cases with 3 or 4 witnesses. It really just depends on the case. This is a lot of witnesses that aren't needed. Will Lally need to plead the fifth during voir dire as he's under federal investigation as well? No, Lally's allowed to ask questions, and I don't know who the targets of the federal investigation are. I think the investigation's investigating the investigation, but Lally was asking the questions and is just continuing to do his job. Mike said, I'm drinking Pedialyte greens and coffee, much needed after a big win last night. Oh, the Celtics won last night. Enjoy your hangover, and that sounds like a fantastic blend to cure the hangover. So Taylor said, thanks for covering this. I think these witnesses will be great at trial. Shell, thank you for the gift of memberships. Megan the Moon said, morning from Detroit area with coffee, water, greens, and sweltering heat. I mean, the greens, the hydration, the coffee. Look at us. We're like, we've got like all of the drink things that we need. We're ready to rock. We're hydrated, we're caffeinated, and we have balance. So, Meg, you are welcome. I was having a hard time getting moving today, but I get to finish Bridgerton today because we have a half day. So, Crystal said, hey, DB, I'm drinking a Cabana Rebel from Dutch Brothers. I'm a Dutch Brothers girl. There isn't one close to me. I think there's one in Murfreesboro. I'm going to have to go try it. Their menu overwhelms me. One time I drove through Dutch Brothers because we were in an area where there was one, and I drove through and I was just like, that's too many options. So I just kind of stuck with what I know because it was too many options. I need to pre-look at the menu and then decide it. Brandy Rose said, in closing, can defense argue how odd it is that the Commonwealth has spent more time trying to prove the innocence of others instead of proving Karen Read's guilt? They can argue whatever they want as long as there are facts and evidence. And I think there are facts and evidence that they have done that. So yes, they can say, look how much time we've spent on Jen McCabe's phone. Why? Why aren't we talking more about Karen Read and what she did? Jay McCarthy said, hey, AJ, your prosecution brain is showing. It definitely was. It definitely was. So Forever Wonder said she doubts FBI witnesses' qualifications, but not the Commonwealth. The defense never moved to exclude the Commonwealth witnesses. So there's that. I think all these witnesses will come in. I will be really shocked if they don't. Miranda said, I don't know. I know it's unlikely that the judge will grant inevitable summary judgment motion, but might she dismiss a second-degree murder charge and allow the jury to deliberate on lesser charges? So when we get to the motion for directed verdict or the motion to dismiss at the end of the Commonwealth's case, I don't think that we're going to see any movement on that at this point. I'm waiting to see the coroner, but here's why I think that. The standard for that motion, just try to wrap your brain around the standard for this motion. This is not directed at you, Miranda. For the chat in general, the standard for the motion is to take everything in the light most favorable to the non-moving party, in this case, the Commonwealth. Every single fact that you're like, that's in question, you have to determine that that fact goes to the Commonwealth. So the in controversy statements by Karen Read, you take them in the light most favorable to the Commonwealth. She hit him. The cause of death, you've got one witness that said this was caused from a car. You've got to go with that was caused from a car. So with the evidence that's in, could a jury determine this when the evidence is all taken in the light most favorable to the Commonwealth? So I think they are going to get over that motion at the end of the prosecution's case. But I still want to see what the coroner says. So will there be a rebuttal for the Commonwealth? God, I hope not. It just depends. I don't know how they rebut these witnesses. I think a vigorous cross-examination, and then what you say is the Commonwealth is, do you believe that? I don't know if they'll do that. Maybe we'll get a rebuttal to the dog bite expert, maybe one. So Lisa Louise said, EDB, you live near Murfreesboro. Yes, it's a lovely part of the country. Yes, sorry, the chat is jumping. Ankitisa, I pronounce that terribly. I'm sorry. Was my favorite place in Tennessee, more so than Nashville. It was so cool to be up in the trees on a mountain. Tennessee is beautiful. It's beautiful. We have more space, which were high top priorities, not high top like the tables. When we moved, it was more space, more affordable living, more favorable taxes, less people. Tennessee has all of those things, and Middle Tennessee has so many incredible universities. It is beautiful. This time of year, we're going to start getting into the less beautiful weather, but it's only for a little bit. And I love summer storms. Lauren said, question, since these experts weren't technically found paid for by the defense, but they can't mention the federal investigation, how is this addressed to the jury? I think we will just see them say, you weren't hired by the defense, correct? Correct. You weren't hired by the Commonwealth, correct? Correct. And just leave it be. So that's where I think we will end up. I saw a couple questions in the chat about what greens do I use. Jessica, I use AG1 because almost every podcast I listen to uses AG1, and I listen to Kelty over here on YouTube. I know she has a code. I forget the name of her channel, but she does a lot of fitness content. I love that she talks about her ADHD and her journey with ADHD and routines and habits and all the rest of it. So she has an AG1 code, but almost everyone I've listened to did AG1, and I'm very much like, oh, I'll try that. And so I tried it. Is Kelty's channel just under her channel name, just under her name? So thank you, just under her name. So I decided to try it because, well, I don't regularly eat greens. So we go with that. I mix it with lemon juice I very much like them. So I love that the chat knows Kelsey O'Connor. That's amazing. O'Connell. I said that wrong. Oh, it's been a day. Thank you, chat. So anyway, so that's what I do. But yes, AG1 is not inexpensive. It works for me. But I try to do things to simplify my life and take care of myself. And it's, for me, it's needed. I was totally influenced, chat. I am highly suggestible. There was Kara and Nate use it too. And I imagine Kara and Nate also have a code. So yes, but yes, I was influenced. There was a time when I was pregnant with, I think, G, and something came on. A commercial came on TV. And this is why YouTube became like my godsend when I was pregnant, because I was so suggestible. A commercial came on for Twizzlers. I had heretofore been a complete Red Vine girl. You could not convince me that I would ever eat a fucking Twizzler in my life. It's like Red Vines are bae. What are you even talking about? That's not real licorice. Also, I love black licorice. So I'm just like, Twizzlers never. A commercial comes on and I look at Dr. B. I'm like, I think I'm going to die if I don't have Twizzlers in my body in the next 7 seconds. Like it must have been like 11 o'clock at night. I was like, I have to have Twizzlers. Highly suggestible. Highly suggestible. Does Phil DeFranco have AG1 as a sponsor? I'm not surprised by that. You know who doesn't? Me. So anyway, so Twizzlers, I was just like, I saw a commercial, completely suggestible, just completely suggestible. And that's what it was. It was the strangest thing because it had not happened. That had not happened to me before in pregnancy, but it was just like, yes, this is why I just can't. This is why I just can't watch commercials, because I'm so suggestible. How do you like black licorice? I don't know. I love it. I love black licorice. I don't know. I don't like cilantro. Do like black licorice. I don't know. It's so good, especially the soft black. Oh, the like British and Australian licorice. Oh my God. The all sorts. Amazing. Lori D1. Will the outcome of the federal investigation be publicly announced? It depends what happens. So it really depends what happens. If there's no charges, we might not learn more. But it really, really just depends on what happens. Do judges consult one another over difficult rulings? It really depends on the case and the judge. Sometimes they do. I don't think today's rulings are difficult, but yeah, sometimes they do. I wish the judge in Georgia would be consulting with other judges, but it really depends on the judge, and it depends on if they like their colleagues in a courthouse, and it just really depends on the judge. So the judges really can't talk to anybody else about things. They just don't. They don't have that ability to. So appreciate you for taking a few minutes to explain. I love to explain what's going on. It is my favorite. I like doing commentary. I thought they planned to bring this doctor only after the prosecution brought in the person who said there was no dog DNA. I don't know if that's the order of things, but it seems the defense has been saying that was the order of possibility for a while. Awkward Aquarian said, is it possible that the defense had a different expert who was going to testify to the victim's arm injuries prior to this expert becoming available? Totally possible. But I don't know. I didn't go through all the pre-trial motions. Well, you could say not saying that the case given the FBI investigators obstructs evidence in the pursuit of justice, but I don't know. I think it would be difficult for the judge to keep those witnesses out. Like, I really don't see why they would. Jane Jam Buddycraft said, question regarding the crash reconstruction yesterday. He said about Mr. O'Keefe's arm hitting the brake light. Why didn't anyone mention or explain how the back of his head and face were damaged? Trooper Paul's testimony was not super clear and organized. He talked about the injury to the back of the head the day before and then left it out when Lally asked him for his opinion. This is the problem. Lally asked Trooper Paul for his opinion like 4 different times, and it shifted throughout those 4 different times. So it's not easy. But the last time he gave the opinion to the jury, it left out the head injury altogether. So there's that. Mary Lou Craft says, my pediatrician was a full-time doctor, went to law school, practiced, and is now a politician, all while still maintaining his private medical practice. I don't know how people do it. Like, my brain couldn't. Amanda said, to take this woman out for drinks and listen. I imagine she has incredible stories. I still have a visceral response to the smell of the LA coroner's office. So I'm just like, it was why I worked as an EMT very briefly. I am very smell sensitive, and that was not for me. Allison said Dr. Russell is the most expert. Dr. Russell has a really interesting CV where you can tell that Dr. Russell followed her interests and was like, oh, I'm interested, like followed her interests and built a career that actually just kind of fits this case. Because sometimes that happens. Smillil said, I'm left with the impression that the Commonwealth is trying to keep very competent witnesses out while they bring their own incompetent ones. And this is why the jury doesn't see the voir dire process. I think the jury will see the witnesses, though. And I think it will be interesting to see if that is a breath of fresh air for the jury, because I think those witnesses felt like a breath of fresh air for y'all. After difficult testimony, after difficult questioning, it just kind of flowed. Some of the questions from Alan were very leading, but it was voir dire. He was trying to speed things along for the court and everybody, because it seems that the court is frustrated and over it. So Slayer says, I call myself a hobby hopper. My ADHD does hobby hop. And the problem is when I pick expensive ones, then it can be a thing. And then my husband's like, why do you have rollerblades all of a sudden? I'm like, this pre-spinal fusion. Why do you have rollerblades? I'm like, I'm going to rollerblade now. He's like, okay. He's like, where'd all this boxing equipment comes from? It's like, I want to box. He's like, okay. And then I tore my ACL. And then it was like, where is this? What is that? Archery has been pretty consistent, though. The nails will be shorter when I get back from VidCon, because it's been getting a little more challenging with the nails. Ford Doherty said, as someone who works at a bank, became a licensed massage therapist, and is now studying forensic psychology, this is validating. Look, you guys, follow your interests. You never know where it may lead. And don't let everyone tell you that you can't. Just follow your interest. It's fine. I'm sure Octo's still in the chat. We did a members only live stream talking a bit about this. Both of us have ended up here through following our interests and the things we like best and leaning into the things we like best. And it's like, what do I like best about what I do? When I left the DA's office, I thought I was never going to touch law again. Like, I am done. I am burnt out. I am sick. I am injured. I am done. And it wasn't law that was the problem. It was the way I was working. It was the demands of the office. It was my own lack of boundaries in that work environment. So there was a lot that I just let kind of break me. And there was a lot that was not healthy about that work environment for me as someone who is highly neurodivergent. But I found a way to still engage with law and do what I love most, which is explaining shit to people. It's what I loved about jury trials. I loved being able to take this complex thing and be like, okay, let me tell you the tea. Like, you're never going to believe it. So this dude was totally money laundering through PayPal. Let's talk about it. Oh my God, this dude was totally stealing people's money as his tax preparer. Oh my God, this dude totally beat up and robbed this person. Oh my God, you're never going to believe what happened in this complex fraud case. Let me tell you, this personal assistant, as their boss was out of town, went through their whole home, took their jewelry, was using photos of them on the red carpet to sell that jewelry online. Can you even believe that shit? You can't do that. So I liked explaining things to people. And when you work in the trial level court, it's all tea all the time, because you get, especially in fraud cases, bank records, jail calls. It's like, sir, your woman is paying for Match.com out of your accounts while you're in custody. So it's going to be real fun for you to sort that out. All the tea, all the time. All the tea, all the time. And then you get to explain it to people. Loved it. You should have Dr. B design a Law Nerd Support Team shirt so I can buy one for my husband. That's fair enough. Law Nerd Support. It's like concert staff. A Reality Check said, what we need to know is, did Alan buy her muffins? Alan, everyone wants to know if there were muffins involved. Because that's the thing. That's the thing we need to know. Let's see. Oh, Sugar said off topic, but my family and I adopted our first cat last night. We're already thinking about a second one. I hear this is how it starts. Yes. Congratulations. You have been chosen by the cat distribution system, and they are lovely and they are fun. And they, cats are loving and amazing. And when they pick their human, there is nothing more fun. My youngest calls George not found, but my oldest is basically like, come along, George. And George is like, and so it's too funny. Cats are amazing. Kyla said, I'm currently working to follow my interests, currently a social worker and studying for the LSAT and GRE so I can do a JD PhD and do research and policy development for immigration law. Kyla, that's amazing. That's amazing. Yes, follow your interests. They are needed. Can they just all agree she can be an expert for everything? Unfortunately not. She's a real life Barbie. What an inspiration. Allie, I love that. Dr. B is the GOAT. He has definitely been keeping us well caffeinated. She's like Barbie. She had every career under the sun. Chat, you guys are so fun. EDB, you 100% need an interview podcast featuring people who are professional court experts. Call it Witness My Expertise. Sam, I love that idea. We will see. We're internal team Baker is all getting together at VidCon. So there's going to be lots of content conversations, and we'll see. We'll just see what happens with that. She's the coolest grandmother ever. I mean, she was an awesome witness. Is Lally leaving the coroner for last so none of the other witnesses can be crossed and disagree with her testimony? I don't know, maybe. So, AJ to the Commonwealth, I see your ER doctor and raise you the queen of all things. The most ERES doctor ever. I said, I really appreciate your input. I bought Alan's outrage at 2 bites of the apple, hook, line, and sinker. His lawyer voodoo performance is hypnotic. There are times where I understand the rage and I will be like, yeah, he should be rage about that. But then there's times you're just like, no rage about that. Lynn said, I wonder how close she is to the truth. And those who know the truth are starting to sweat. I don't know. I so want her to bring up something to do with confirmation bias. I'm sure it'll get asked of some of these witnesses. I'm sure the last 2 witnesses, particularly the accident reconstructionist, I'm sure Alan will say, do you know what confirmation bias is? It will be fantastic. Sienna said, my puppy accidentally hit me during play and the wounds look just like the picture, only shallower. Or accidentally bit me during play. I mean, Yellow Pill MP said she has nothing to gain by being here. She needs no notoriety from testifying in a high-profile case, given all she's achieved. A woman in medicine and law enforcement and contributed to literature. Yeah, I didn't get the you're only here for your 15 minutes of fame from that witness. Here's what I took away. I would love to know what you think, because the court was like, we just don't want people like coming out of the woodwork and offering their help. The court was so worried about it. But here's what I saw. Somebody who has dedicated their life to solving problems and has continued to work to solve problems and saw a problem and went, if you've got a problem, yo, I solve it. I'm sorry, it was too easy. But if you got a problem, yo, I solve it, and was talking to another LADA who works cold cases and had that conversation and then reached out to the attorneys and the attorney went, holy shit, she's really well qualified. It just seemed to me like someone who wants to help. That's what I took away. So that's what I took away. Ty said, question, is it possible that the defense had a different dog bite expert that was not as good? It's possible. It's absolutely possible because the defense knew this. But what Alan Jackson was saying is we turned this over 3 days after we discovered it. So that's adequate time, even though it was in the middle of trial. The court didn't agree. What is the Rule 14 they keep mentioning? It is Massachusetts rule on reciprocal discovery. We talked about it, at the beginning of trial, which was like 8 weeks ago, but we talked about it a bit more then. But it's about when things need to be turned over. Tinsley, good to see you at this point. The judge clearly is biased. I think the judge is frustrated. And there are times where the way that the judge tries to get information out of Lally is too pointed for me. If Lally doesn't make the arguments, it's not for the judge to be like, well, what about this, Mr. Lally? No. If he doesn't argue it, then he doesn't argue it. It's not for you to ask unless he's not addressing something specifically. Can you specifically address this argument? But it's a lot. Did AJ work with Dr. Russell in LA? Elizabeth asked. He said no, they've never met before, but it seems that that doctor is working with a different DA that AJ knows. Jay said, can we all just appreciate how the judge got rude with AJ and he called her on it and she quickly backed down? Yeah, she did. I don't think she was prepared for his prosecution background. Oh no, he's outside the presence of the jury. He's not going to clap back at the judge like that with the jury there, but he did with this. Debbie said, love your teaching of law. You make it fun. I hope so. I think that we all do better when we understand, you know, the systems that run our entire lives. The laws impact everything we do, from, you know, the type of straws you can drink out of, the type of cups we have, to whether or not you can be arrested for something, your phone can be searched and what have you. All varying aspects of our life are touched by the immense amount of laws we have here in the US. So I think everyone should get to understand that. I don't think it should be gatekept. And I think courts should be transparent. I mean, that's what I ask when I ask about platforms doing stuff too. I ask that the platforms be transparent. A snake named Michi said, I'd love if some Law & Order merch was pins. We are working on that. I don't carry cups and stickers don't stick to my wheelchair or wheelchair bag, but pins would. We have been working on pins. So yes, we've been working on pins. My neurodivergency led me to be a driving instructor. Also, do you want me to send you all sorts? I have all sorts at my local grocery store. Thank you for the offer. That's very kind, but I've got them. What needs to happen for BA to be investigated? T-Lou, sorry, my throat just got all junky. Apologies. What needs to happen? There's an investigation going on. So Runkle said, how many, if any, of the snacks are left? We have snacks left, and I have some set aside to send to Rob. Julia said, anybody have suggestions on the starting point to find a Chicagoland therapist specializing in ASD and ADHD? Asked my great psychiatrist, but no help. Hopefully the chat had some recommendations, but you will just have to kind of go through the local process. I would ask the people that you know, and if your therapist doesn't know, maybe ask around to other therapists who work with counselors that they like on a team, or your physician might be a good place to start as well. It can be hard to find the right fit. Amber said, which MSP trooper is going to be cramming in medical courses to become a rebuttal witness next week? Probably Trooper Paul. The judge looks like Polly Purebed from Underdog. I can't picture things in my head. I will Google. Sweet Pea said, when I was preggers, Twizzlers and Coke Zero were my jam. Alicia said, do you think that after all Bev has seen, this preview of defense could earn a directed not guilty verdict, save the jury some time? I don't think so, because I think the standard works against it, which I talked about earlier. Art, design, photography, now psychology. Yes, that witness did all of the things. DSN, thanks for the gift of memberships. And thank you for 8 months. I'm happy for us that you took care of yourself. Well, thank you. I try to, because, 8 weeks is a lot. My voice, I can feel. Ice Baby said, I worked in Chicago radio for 10 years. Wasn't awful, DJ. I needed the energy of others to do well. All of the dead air became a promotions and marketing director and excelled. Now I'm a therapist and want to be Dr. Drew. Ice Baby, I love that. And you're like, did all the thing, but the marketing director would be very fun. And yes, sitting and having conversations sometimes one way can be difficult. That is why I like to live stream with chat. Chat gives me energy. People are like, Emily, videos on demand can get more reach. I'm like, there was no chat. Emily, you should do this thing on TV. I'm like, there's no chat. Like, when people ask, how do you decide to do this? I'm like, chat. I decide to do this via chat. Is there a chat? Great. I love chat. Brittany said, Emily, I love watching you during the day and getting your outlook and then catching Lawyer in the evening, same wavelength. There are times, and look, when you're watching Lawyer Ian Runkle, Natalie Lawyer Chick, they are all actively working. I understand the summaries, and sometimes I'm like, oh, it would be so fun to watch this in advance and then go back and do it with a second take, but I think for me, I wouldn't be able to constrain it. And I want to give you my first look, which is why I think there's lots of room for both gavel to gavel and summary. And I think you guys should hear what everybody thinks. You get so many different perspectives of lawyers that have worked in all different types of fields. I love it when Peter brings his dad on. His dad's resume is fucking baller. Like, Peter's dad, not to dismiss Peter's own resume and qualifications, but Peter's dad's career is fucking fire. And it's really interesting to see their differences in opinion. And that is incredibly cool that you get the perspective from so many different people that have worked in different ways, seen different cases, and come at things just from a different perspective. I love it. I think finding different voices is incredibly important across all content. And that includes voices you agree with and voices you don't always agree with. I will watch all different kinds of content. And there are times I'm watching something and I'm just like internally like, well, often externally like, no. But then I get to evaluate why I disagree, how I disagree, what that disagreement's based on, which keeps me able to evaluate things I think better. So I love it. Let's see. Shouting into the void. Hello, welcome to the internet. It bothers me that we have talked more about John O'Keefe in chat than they have in court. None of this feels like justice. Shouting into the void, I completely understand how you feel. This is not uncommon for criminal process. This is often how cases work. The victim is generally talked about minimally, often talked about sometimes as the decedent. Not all courts allow the victim to be referred to as the victim until it's determined that a crime happened. John O'Keefe died unnaturally, so he is a victim of something. Who or what happened is different, but some courts go with decedent to be neutral and fair to the defendant, who is the person on trial. The way that our Constitution is set up, the rights of the accused come first. So we often hear much more about the victims after a conviction. If there's not a conviction, we do not hear a ton about the victims in cases because of the way that the rights are set up and because it is the government trying to take away the rights of the accused, especially when they are trying to put them in jail for extensive amounts of time. So it is a push-pull. There has been a lot of work in victims' rights and victims' rights advocacy. So victims are, at a minimum, told what's happening with a case, which doesn't happen in every jurisdiction. So it is growing, but I think it is a very real tension and worth noting. C-Star said, what made you decide to cover this case? Lots of law nerds had asked about it. And when I started to take a peek into it, I went, oh, there's real questions here. And there, I think, is room to have a conversation about what's happening in this case. It is not a cut and dry case. It is not an open and shut case. It is a very interesting case with real legal issues and arguments. And then I took a look at the fact that Jackson was the defense attorney, and I was like, I'm okay. I'm interested. I'm in. I know he's a good trial lawyer. I'm in. Let's just take a look for ourselves. And that's when I decided I wanted to go in as a juror and say, let's just see what happens. Let's see how the evidence comes in. Let's see how the witnesses present themselves. Let's see how the arguments are made. Let's see what the opening statements show us. And it's been very interesting to be surprised because you don't know what's coming, or I don't know what's coming. When we get to like the text messages, I'm like, what's there? And then there's times they go through them and it's like, that's it? Is there more? Where's the more? I'm waiting for the more. So we get to keep curiosity. And then 8 weeks in, we're just like, whew. And if this trial backs right up to the Baldwin case, we're not going to have any trial downtime. We're just going to be like, keep rolling, one case to the next. If they overlap, I don't know what I'm going to do. Will you have a Law Nerd meetup in the OC after VidCon? Barry SD, I have to get right back home after VidCon because I think we're still going to be in trial. So I am scooting out. I do not have time for a meetup this round. We are trying to build those in, but with trial testimony, I've got to get back. I've got to get back home. I have an incredibly busy schedule at VidCon, which I am blessed to have, but it's going to be a busy week. And I'm going to be streaming at 6 a.m. from my hotel room. It's going to be good. But then at least we're clear by 1 p.m. So Jay said, thanks for the explanation. It explains why Dr. Russell changed from victim to decedent. I love her even more now. Right. Krista said, Lily from the Do We Know Them pod was on hearing and was told, Miss Marston, you need to work on your poker face. And it reminded me of you. Couldn't be a judge or juror either because my face could never. Jurors don't really have to constrain themselves as much. Litigants do. The parties do. Those sitting in court, the audience does. The jurors kind of get to be the jurors, but the audience and the people in the courtroom other than the jurors definitely need to rein it in. Not all criminal defendants do that, and it doesn't always go well. So, chat, do you see the stark difference between the experts? Emily, yes, there is the North remembers amount of stark. The kill me expert was such a mood in this trial. It was just such an odd hot mic. How did the grand jury overlook this testimony? The state grand jury didn't have this testimony. Oh, sorry if that is loud. The state grand jury did not have this testimony. I have not tried Celsius water. Let's see. I love these experts. Breath of fresh air after Trooper Paul. I collect data and need to know the when, how, who, and why, which is hard in this case because I feel like the steps are just not explained. It's frustrating. Sandra said, thank you, Emily, for your excellent commentary and analysis. You're welcome. My sister Cynthia and I really enjoy following your channel. We are watching you from Singapore. Hello, Sandra and Cynthia in Singapore. I feel like the judge is trying to lawyer from the bench. There are times it feels that way, as if she were the prosecution at the prosecution table today. I felt she was very hostile today. The judge is getting, I think, antsy. Nicole said, I get the judge is human, but if she's so over it that she's bothered by the defense having a defense, she's in the wrong career. Yeah, it's literally her job. Will Lally rebut these experts preemptively? Maybe a little bit. Gingy Prob said, Emily, I just finished watching the 2020-2021 Durst case. I'm obsessed with John Lewin's court style. So happy to hear him shout it out today. Yes, the second they said John Lewin, the chat was like, Durst. And for those of you that didn't watch the Durst trial or watch Jinx, you will get the coverage of that. One of my favorite judges in LA County is the judge on the Durst case. And I could not fangirl enough. I think he's great. Michelle said, who is the guy seated to the left of the podium each day? He is the media or the tech guy for the defense. So when the defense needs exhibits and stuff pulled up, he is their tech person. Remember, the judge at the beginning was like, I don't know if you can have a tech person in court. We don't have enough room at the table, blah, 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 blah. There's 3 attorneys plus the defendant. And the state has their table with, Lally, I think that's the other DA, and then their tech person. So that little table with the little chair is the defense's tech individual. Why does it have to be a rehome dog residential area and other people have dogs? I don't know. I don't know why they rehome. Well, I think we know why they rehome the dog. They said they rehome the dog after the dog bit somebody. Ronnie said, wait, am I hearing this right? The defense has 2 doctors on their witness list for accident reconstruction and the prosecution witness has an associates. Yeah, that's why the defense asked the questions that they did. Commonwealth is offended FBI involved and is taking it out on Karen Reed. They shouldn't be doing that, but they have no control over what the feds do they? Melanie said the judge must be overheated. I think the judge is probably stressed because if they're going to start losing more jurors, which is a real possibility, I can see why the judge is stressed. So, let's see. Annie said, why voir dire these 2 witnesses? Because the Commonwealth made a motion and it was unclear from these witness reports who did what, because the reports said we, and neither side were allowed to prep these witnesses because they come from the other investigation. So that's why I just do it in court and then everybody's on the same page. What did the grand jury conclude? Brandy asked, we don't know yet. Why are the last 2 voir dired? Were their opinions not available? It's because of the way the reports were written. So Tara said, will the defense have a plan B if Bev doesn't allow the doctors, or will they be SOL? I mean, I don't know if they'll take a writ. I don't think that these will be kept out though. Jack said, who is Bev's boss? I mean, If the judges are elected in Massachusetts, and I don't know if they're elected or appointed, then it would be the voters and sometimes the site judge. Judges can be quite hard to remove if they are not elected. Lynn says, love you, EDB. I can't get past Trooper Proctor. After him, I doubt everything the Commonwealth brings in, which is why it's interesting when they brought Trooper Proctor in, right? It taints everything that he touched. Sweet Pea said, if the DOJ finds that John O'Keefe's injuries are inconsistent with a vehicle strike and the jury finds her guilty, can Karen Reed appeal? If Karen Reed is found guilty, she is going to appeal. So that just full stop. If she is convicted of anything, she will appeal. But the grounds for the appeal will vary depending on what happens and what comes out in testimony. If the DOJ doesn't agree, why prosecute? I don't know, but it seems that the DOJ has not given any conclusion yet and that they haven't said why they are investigating, and the Commonwealth was going forward with this long before. But the Commonwealth and the defense both asked this case to be continued, especially in light of the federal investigation, and the judge said no. I don't know if the Commonwealth could have had the ability to dismiss and refile, but I think it would have been difficult to do in a high-profile case like this. But they asked for more time, and that's tough. Okay, that is getting incredibly loud. So with that, I am going to get wrapping up because it is incredibly loud, and I apologize. Normally, when we're covering trial, I can just mute it. I saw the question in the chat. Am I saying Charmander site, S-I-T-E, like on site? The judge. They will call them different things. The chief judge, the site judge, the supervising judge, but there is a hierarchy, like all government things. There is a hierarchy of judges and who is in charge of who, but largely they have to make their own determinations of things. With that, Law Nerds, I am going to wrap. We're just about 4 hours in. How did we get to 4 hours? How did we get to 4 hours? But if you are still here, thank you. Do the YouTube things. I appreciate you. Like, subscribe, all that good stuff. Tomorrow, there will be a new podcast episode. We are talking on the podcast tomorrow. And for all of you that are here, you hear this first. Buster Murdaugh suing for defamation. Updates, kind of, about what Hannah Gutierrez-Reed might be testifying to if she has given use immunity later this week. And what is going on with this new motion for mistrial in the YSL Young Thug case. So that is the podcast for tomorrow. We will let you know when it's live on the Law Nerd app. We will let you know. But there's lots going on for tomorrow. So yes, the Buster Murdaugh suing Netflix of it all is tomorrow's podcast. So that is on all of your favorite podcasting apps. It also goes up on the channel at 11 a.m. Central. I know those of you that waited to the end are like, wait, what? We have lots to talk about. So that's for tomorrow. Thank you for being here. Thank you for being a Law Nerd. I appreciate you, and I will see you in the chat tomorrow for the podcast and back in court on Thursday, unless the court does something wonky or it gets too hot or whatever. And then we'll see. I'll keep you posted in the app. See you guys soon. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.